Yes.
Weekly list item number 25.
I'm citing the evidence, citing the memo of pressing on the circumstantial evidence. Well, the chain of circumstances has not been completed.
Yeah.
Criminal appeal number 119 of 2020, decided on 22/2020 in Mohammed Yunus versus Ali Tarfdar versus State of West Bengal. Decided on 22/2020. The second item is Manupatra 0048 of 2021 in the criminal appeal number 84 of 2005, decided on 4/3/2021 in the case of Dilip Pradhan versus State of Odisha. The third case, my lord, decided on 23/12/2022 in Rajesh Thappa versus State of Odisha.
This observation of the Honorable Supreme Court that has been referred to in one of the judgments. The classic thing that Hanumant Govind Nagunkar and another versus State of Madhya Pradesh 1952 to Supreme Court 5343 last judgment.
Yes, that we call it as locus classicus.
The mind was apt to take a pleasure in adopting the circumstances to one another, and even in straining them a little, if need be, to force them to form parts of one connected whole. And the more ingenious the mind of the individual, the more likely was it, considering such matters, to overreach and mislead itself to supply some missing link that is wanting, to take for granted some fact consistent with its previous theories and necessary to render them complete. So, Mr. Mishra,
Lordship.
we were discussing yesterday that there are basically two circumstances that has been established by the prosecution.
Got you.
One is that leaving the place, uh, courtyard, not the courtyard, and one of the three persons, that is 1, 5, and 7, six row, PW1 has seen one tangia in the hands of this appellant number 1. That is one circumstance. The second one is that in appearance in the police station producing that tangia, and you seize that tangia, sent it for chemical examination, and it was found that there was no stain of blood, and even the wearing apparels also, there was no blood. And even PW1 has not stated or identified that particular, then no attempt has been made that the tangia which was produced by the accused persons in the police station, another police station, that was the tangia which he had seen in the hands of the appellant number 1. So these are the only two circumstances. All right, please take your seat. DCRL number 19 of 2008. The two appellants, Purastama Pradhan and Karna Pradhan, are brothers. And they faced trial in the court of London Additional Sessions Judge Nayagar in ST case number 20 of 2005 for offences punishable under section 449 and 302 reduce section 34 of the Indian Penal Code on the accusation that on 3/8/2004 at about 3 p.m. at Gonikumpa bracketary Kerabari, they committed house trespass by entering into the house of informant Vikram Pradhan bracket PW2, used as a human dwelling in order to commit murder of his younger brother Rabi Pradhan bracket hereafter the deceased, and also committed murder of the deceased. The London trial court by the impugned judgment and order dated 30/1/2008 found both the appellants guilty under the offenses charged and sentenced each of them to undergo rigorous imprisonment for life and to pay a fine of rupees 5,000 each, in default to undergo further rigorous imprisonment for 1 year under section 302(y)34 of the Indian Penal Code, and to undergo rigorous imprisonment for 3 years and to pay a fine of rupees 3,000 each, in default to undergo further rigorous imprisonment for 6 months under section 449(y)34 of the Indian Penal Code. And the sentences were directed to run concurrently. The prosecution case, as per the first information report lodged by PW2 Bikram Pradhan before the officer in charge of Daspalla police station on 4/8/2004 is that on 3/8/2004 in the afternoon at about 3 o'clock, while the deceased, who was the younger brother, who was his younger brother, was sleeping in the house, both the appellants entered inside the bedroom of the deceased, being armed with Barishi and Tangia, and committed murder by assaulting on the neck and chest and abdomen portion of the deceased, and left the spot, leaving one Tangia at the scene of occurrence. The father of the informant sent him to intimate the incident to one Prasanna Behera. It is further stated in the first information report that relating to cultivation of paddy crops, there was a quarrel with the deceased, and on account of by the appellants with the deceased, and on account of such incident, the murder was committed. On receipt of the written report, the officer in charge of Daspalla police station registered Daspalla PS case number 81 dated 4/8/2004 under section 449(302)(y)34 of the Indian Penal Code against the appellants, and took up investigation of the case. No, ତା ପୂର୍ବରୁ ଲେଖନ୍ତୁ, ସେଟା ଟିକେ modulate ହବ. On 3/8/2004, the PW 15 Subhas Chandra Mahanti, the officer in charge of Daspalla police station, at about 8 p.m. Received telephonic information from one Prasanna Behera about the murder of the deceased, and accordingly he entered the fact in the Daspalla PS station diary entry number 57 dated 3/8/2004 and proceeded to the spot at about 9 p.m. and arrived there at about 11 p.m. And on his arrival at the spot, he found the dead body of the deceased lying on a charpoy with a pool of blood on the ground and an axe stained with blood lying near the dead body on the ground. And he also noticed cut injuries on the right neck, right chest, right side belly. He guarded the spot through his staff, and at about 11:45 p.m., PW2 lost the uh, presented a written report before him at the spot. And accordingly, on the basis of such a report, say you request a register on 4/8/2004 by SI of Police Dasarathi Naik. The photographs of the spot was taken when the IO visited the spot on 4/8/2004, and he also prepared the spot map bracket Exhibit 14. He held inquest over the dead body and prepared the inquest report Exhibit 2. He also seized the bloodstain earth, sample earth, and bloodstain axe with handle as per seizure list Exhibit 3, and sent the dead body for post-mortem examination to the Daspalla Hospital. He also seized the wearing apparels of the deceased and command certificate, which are produced by the escorting constable after returning from the post-mortem examination. On receipt of a telephonic message from Circle Inspector of Police Baud that both the appellants have surrendered at Hadavanga Police Station on 4/8/2004 with an axe after confessing their guilt, he made the station diary entry and left for Harbanga. And at about 8:30 p.m. on reaching Harbanga police station, he found both the appellants to have been detained there with the weapon of offense. And at 9:15 p.m., the IO arrested both the appellants. And on the very day at about 9:15, on the very day, he also seized the handle of the axe, and from the portion of the axe kept separately and the front portion of the axe kept separately on production of the appellant number 1, Purushottam Pradhan, as per seizure list Exhibit 13. On 5/8/2004, the IO seized the wearing apparels of both the appellants at Daspalla after bringing them from Harbanga police station in the previous night as per seizure list Exhibit 5. And on the same day, he sent the appellants to Daspalla Hospital for collection of the nail clippings, and he also sent the weapon of offense, that is the handle and the iron portion seized at Harbanga, for opinion of the doctor, and subsequently seized the nail clippings from the accompanying constable as per seizure list Exhibit 9. And forwarded both the appellants to court. On 12/8/2004, the IO made a prayer to JMFC Daspalla for sending the exhibits to SFSL Rasulgarh for chemical examination. On 10/8/2004, he received the postmortem report and photographs, seized the station diary book of Harbanga police station as per seizure list exhibit 18 and released the same in the Jima of ASI of police as per Jimanama exhibit 19, and on 11/12/2004 on completion of investigation, he submitted charge sheet against the appellants. After submission of charge sheet, the case was committed to the Court of Session compliance of the procedure and where the Lenin trial court framed charges as aforesaid. Since the appellants pleaded not guilty and claimed to be tried, the sessions trial procedure was resorted to prove their guilt. During course of trial, the prosecution examined as many as 15 witnesses. The prosecution also exhibited 20 documents and also proved 7 material objects. These are these ones. The defense plea of the appellants is one of denial. The Lenin trial court, after assessing the oral as well as documentary evidence on record, came to hold that from the evidence of PW 9 and exhibit the doctor conducting the PM doctor and exhibit 7, no, exhibit 6, the postmortem report, it is proved that the death of the deceased was caused instantaneously due to stoppage of respiration and hemorrhage, and the death is homicidal in nature. The Lenin trial court further held that from the evidence of PWs 1, 5, and 6, it is clearly established that soon after the occurrence, they reached at the spot and found the deceased lying on a cot and also the appellants leaving the spot. And from the evidence of PW1, it is clearly established that by that time, the appellant number 1, Purushottam Pradhan, was holding a tangia stained with blood. The Lenin trial court further held that from the evidence of PWs 12, 13, 14, and 15, it is clearly established that soon after the occurrence, both the appellants fled away from the spot and surrendered at Harbanga police station and gave voluntary statement before PW 13 and PW 14 regarding their identity and involvement with the occurrence. It was further held that the confession made by the appellants in the case before the police staff, even if is not admissible in evidence, their surrendering along with production of weapon of assault suggests the inference that they have committed the crime. The Lenin trial court further held that from the chemical examination report Exhibit 20, it is established that the acts in which the deceased was assaulted contained human blood of O group and ultimately concluded that the appellants caused the murder of the deceased after assaulting him by means of tangia on different parts of his body after committing house trespass to his dwelling house, and accordingly the prosecution has well established the charges against the appellant under section 449 and 302 of the Indian Penal Code. Ms. Vijayalakshmi Tripathi, Learned Counsel, appearing for the appellants, contended that there is no direct evidence in this case. The case is based on circumstantial evidence, and the circumstances proved by the prosecution are not clinching and they do not form a complete chain so as to come to an irresistible conclusion that it is the appellants who have committed the murder of the deceased. The Land Council further argued that merely because the appellants were seen fleeing away from near the spot and at a later stage they surrendered at the Hadabanga police station with one axe cannot itself be a ground to convict the appellants. It is argued that even though PW1 has stated to have seen the appellant number 1 Purushottam Pradhan to be holding one axe, but PW5 and PW6 who almost accompanied PW1 to the scene of occurrence have not stated to have seen any weapon in the hands of appellant number 1. The Learned Council further argued that even though the appellant stated to have confessed before PW14 regarding commission of crime in Hadbanga police station in view of the bar under section 25 of the Evidence Act, the confessional statement is not admissible, and though a tangia is stated to have been produced by the appellants at Hadbanga police station, but when it was sent for chemical analysis, no blood was detected on it, and moreover, there was no link established between the weapon seized at Hadbanga police station from the possession of the appellants with the commission of murder, inasmuch as PW1 has not identified the axe to have seen in the hands of appellant number 1. The Land Council submitted that in view of the available material on record, it is a fit case where benefit of doubt should be extended in favor of the appellants. Mr. Shonak Misra, an additional standing counsel, on the other hand, supported the impugned judgment and argued that there was a dispute between the appellants and the deceased, which would be evident from the evidence of PW1 and 2. And the prosecution has also established that the deceased met with a homicidal death. He argued that the appellants were seen leaving the spot and PW1 has seen the that appellant number 1 holding an axe at that point of time. and at the spot the dead body was lying with multiple injuries, and another axe was lying there. The Lennon Council further argued that even if the confessional statement stated to have been made by the appellants before PW 14 at Hadabanga police station is taken out of consideration, but the production of the acts by the appellants is a conduct which is admissible under section 8 of the Evidence Act, and therefore the chain of circumstances is complete, and there is no infirmity in the impugned judgment which should be, and accordingly the appeal should be dismissed. Adverting to the contentions raised by the Lennon Council for the respective parties, let us first examine whether the prosecution has successfully proved the homicidal death of the deceased or not. The doctor examination. Mr. Mishra, doctor has been examined. PW?
PW 9.
Yes, sir. Oh.
PW 9.
The dead body was sent for postmortem examination on 4/8/2004 to area hospital, Daspalla, where PW9 Dr. Pradeep Kumar Das conducted postmortem examination, and he noticed the following injuries. The doctor opined further that the injuries are antemortem in nature, and except injury number 4, all the 3 injuries are grievous in nature. And injury number 1 caused the immediate death due to stoppage of respiration, and he further opined that all the injuries were caused by sharp cutting heavy weapon, and the cause of death was due to stoppage of respiration and hemorrhage, and the death was homicidal in nature. The doctor also examined the 2 acts which were sent by the investigating officer in making a query regarding possibility of the injuries sustained by the deceased with such weapons, and after examining the same, the doctor PW9 opined in affirmative and stated that the injuries found on the body of the deceased could be possible by such weapons, and the postmortem report has been marked as Exhibit 6, and the query report and the opinion report has been marked as Exhibit 7. Nothing has been brought out in the cross-examination of the doctor, and no challenge has also been made by the Lennon Council for the appellant to the nature of death of the deceased. In view of the available material on record, we find that the Lennon trial court has rightly came to the conclusion that the death of the deceased is homicidal in nature. Coming to the dispute between the appellants and the deceased, the evidence of 2 witnesses, that is PW1 and PW2, are relevant. PW1 has stated that on the date of incident, his deceased son had gone to the land of the appellants to cultivate on bhag basis, but he was restrained by the appellants, for which he came away. whereas PW2, who is the brother of the deceased, has stated that on the date of occurrence in the morning, the deceased went to cultivate the land of Jamuna Pradhan and appellant number 1, since they had requested to cultivate the same on bhag basis. Since there was dispute in the family of the accused persons, on hearing the fact, PW2 went to the deceased and restrained him not to cultivate the land of appellant number 1, for which the deceased cultivated their land and stopped. Therefore, the evidence of PW1 and PW2 on this aspect is completely contrary to each other, and though PW1 has stated that the accused persons restrained the deceased from the cultivation work, the evidence of PW2 rather indicates that it is he who restrained the accused, he restrained the deceased from cultivating the land, as there was dispute in the family of the accused persons. From the evidence of these two witnesses, that is PW1 and 2, it is difficult to accept that there was any such dispute between the appellants and the deceased prior to the occurrence for formation of motive behind the commission of the crime. Next para. Coming to the evidence of PW1, PW5 and PW6, who have stated to have seen the appellants leaving the spot, it appears from the evidence of PW1 that at the time of occurrence, he was at his Salaghar, which was 100 yards away from his house where the deceased was sleeping. And he heard shout and came to the spot along with PW5 and PW6 and found both the appellants near the door of his house, and they were saying to cause assault if anybody would come. Bracket re au kia sucho aso hani debu. Bracket ends. The appellant number 1 was holding a tangia which was stained with blood, and out of fear he could not detain them, for which they went away. PW1 further stated that when they entered into the room, they found the deceased lying dead on a cot and being assaulted on his belly, chest, and neck, and the neck was half cut. And one tangia was also lying there, having bloodstain, and there was bloodstain throughout the room. In the cross-examination, however, he has stated that he found the appellant standing in front of the house on Dando from his sala, and he heard the appellant saying "Kie asucho aso" from his sala, and found the appellant number 1 was wearing a lungi by that time. And he further stated that when he reached along with PW5 and PW6, the appellants fled away, and from a distance of 50 yards, he saw the appellants fleeing away. It has been confronted to PW1 and proved through the investigating officer, bracket ray PW 15, that he has not stated in his 161 statement that he saw the appellants near the door, but stated that he saw the appellants in the courtyard. He stopped. The other two witnesses, PW5 and PW6, who according to PW1 accompanied with him, have stated in a different manner. PW5 has stated that on the date of occurrence, he had gone to the Salah of PW1, and PW6 was also present there. And at about 2 p.m., the occurrence took place, and PW1 went to his house and saw the deceased lying dead. And then he himself and PW6 went to the house of PW1 and found the deceased lying dead after being assaulted. And he further stated that he found both the appellants going away from their backside when PW1 shouted. Thus, PW5 evidence is silent to have seen any weapon in the hands of the appellant number 1, Purushottam Pradhan. PW6 has stated that he, along with PW5, were present in the Salah of PW1, and there was Halla Hanidele from the house of PW1, and from the Salah he witnessed the appellants going away. And then he the PW1 went to his house first, and then he himself, along with PW5, went to the house of PW1 and found the dead body of the deceased lying on a cot, and Tangia was lying there. He further stated that the appellants, it has been confronted to the PW6 and proved through the IO bracket ray PW15 that he has not stated to have heard at the Salah the shouting that inverted comma bitere hani dela. Stop. Like PW5, PW6 evidence is also silent regarding seeing of any axe in the hands of appellant number 1. On a conjoint reading of PW1, PW5, and PW6, on whom reliance has been placed by the London Trial Court, we find that though all the three have stated to have seen the appellants leaving uh, from the courtyard of the house of PW1, but so far as the weapon stated to have been so far as the act stated to have been noticed by the appellant no, by PW1 in the hands of appellant number 1 is not getting corroboration from the evidence of either PW5 or PW6. So also the utterances stated to have been made by the appellants. The next piece of evidence available against the appellant is the evidence of PW14. Hajari Naik was a constable attached to Harbanga police station, and he has stated that on 4/8/2004 at about 4 p.m., two persons arrived at the police station with a tangia and confessed before him that they committed murder of a person and requested to save them. And on his interrogation, they expressed that out of fear they had come to a distant place. PW14 further stated that he detained them and intimated Badababu over VHF, who directed him to detain both the persons in custody till his arrival. And those two persons were wearing lungi and gamucha, and the lungis were stained with blood. The tangia was separated from the iron portion, and he further stated that in the same night at about 7:30 p.m., Badababu, Judhishthir Behra arrived at the police station, and at 9 p.m., PW 15, the OIC of Daspalla police station reached there and seized the tangia along with the handle on the same day at about 9:30 p.m. The tangia was marked as MO3 as per the evidence of PW 14. Though PW 14 has not stated that those two persons were the appellants standing in the dock, but the Lenin Defense Council has brought in the cross-examination that the appellants appellant number 2, Karna Pradhan, was holding the tangia when appeared at Harbanga police station. And in the cross-examination, it has been elicited that he kept the appellants inside the hajat. PW13, on the other hand, PW13, who is another constable attached to the Harbanga police station, stated that the appellants came to the police station and told to PW14 regarding commission of the murder of their brother, and one tangia was with them, which was also kept in police station. However, in the cross-examination, he has stated that at about 2:10 p.m., when he reached the police station, by that time, the accused persons were in the hajat, and the tangia was kept in the room of OIC. If according to PW 14, the two persons arrived at the Harbanga police station at 4 p.m., whereafter they were detained in Hajat, and the Tangia was kept in the room of officer in charge of Harbanga police station. The evidence of the PW 13 that at about 2:10 p.m. when he reached at the police station, by that time the appellants were in Hajat and the Tangia was kept in the room of OIC is somehow discrepant. Be that as it may, the confessional statement made before PW 14, the constable in Harbanga police station has been rightly taken out of consideration by the London trial court. Even though the Tangia and the wearing apparels of the appellants were seized and sent for chemical analysis, but the CE report, which has been marked as Exhibit 20, indicates that bloodstains could not be detected in the wearing apparels as well as in the Tangia. PW 1, who has stated to have noticed the appellant number 1 to be holding a Tangia while leaving the spot, has also not identified MO3 to be that Tangia. In fact, he has stated in his cross-examination that he was not witnessing the Tangia in the court. Therefore, no link has been established that the Tangia, which was stated to be in the hands of appellant number 1, seen by PW1, was the same Tangia produced before the Harbanga police station on 4/8/2004. And moreover, since no bloodstain was noticed on the Tangia, its recovery is no way relevant for establishing the guilt of the appellants. Even if the conduct of the appellants in producing the Tangia can be is admissible under Section 8 of the Evidence Act, but unless the Tangia is proved to be the weapon of offense, its seizure is no way helpful to the prosecution in establishing the guilt of the appellants. In the off-court decision of the Honorable Supreme Court in Sarad Brichyan Sada versus State of Maharashtra, reported in AR 1984, Supreme Court 1622. The principles relating to the appreciation of a case based on circumstantial evidence has been discussed, and 5 golden principle or panchasila has been laid down, which are as follows. Quote this. It is the settled principle of law that the circumstances concerned must or should and not may be established, and the circumstances from which the conclusion of guilt is to be drawn against the appellant should be fully established. In the case of Hanumant Gobind Nagunkar and another versus State of Madhya Pradesh, reported in 1952 to Supreme Court 343 check kar debe. It has been held that in dealing with circumstantial evidence, the rules specifically applicable to such evidence must be borne in mind. In such cases, there is always a danger that conjecture or suspicion may take the place of legal proof. The lordships relied upon the decision in the case of Rake versus Hodge 1938 to Levin 227, where it is said, inverted comma vitre, the mind was apt to take a pleasure in adapting circumstances to one another and even in straining them a little, if need be, to force them to form parts of one connected whole. And more ingenious the mind of the individual, the more likely was it, considering such matters, to overreach and mislead itself, to supply some little links that is wanting, to take for granted some fact consistent with its previous theories and necessary to render them complete. In the case in hand, even if it is accepted as per the evidence on record that the appellants were seen at a distance from the spot, leaving the spot, going away, and that appellant number 1 was holding a tangia, and on the very day one tangia was produced at the at Hadbanga police station. In absence of any other evidence, it is very difficult to come to the conclusion that the chain of circumstances is complete and that the circumstances taken together unerringly point towards the guilt of the appellants. There are missing links in the chain of circumstances, and therefore we are of the humble view that the Lennon trial court was not justified in convicting the appellants on the basis of such circumstantial evidence for the offenses under section 449 and 302 by 34 of the Indian Penal Code. In the result, the jail criminal appeal is allowed. The conviction of the appellants under section so and so hereby set aside. They are on bail or they are in custody? Huh? They are. It is state High Court of Orissa. It appears that both the appellants were granted bail by this court as per order dated so and so. Though they are discharged from this one.
Appellant number 1 was on bail. 2 has already been released on premature.
Acha, so and so per appellant number 1 was granted.
1
bail,
was granted bail.
Appellant number 2 can filed.
Premature released.
We have filed an instruction to that effect, Your Lordship.
Appellant number 2 instruction filed so and so. Yes, sir. हाँ देखिए Yes. Mr. Misra, any other counsel? And
Item 45, Madam Mr.
Yes.
45.
45 conclusion. Just a minute.
Item number 45.
Report book करती है. $74 of 2000 figures. Mr. Misra, you will do this case.
Lordship.
Okay. Yes, you can ask. Yes.
Here in this case, my lord, 2 appellants here. They are 2 brothers, and both have been convicted under section 20 and sentenced to undergo RI for life and pay a fine up to 10,000. Lord, for your lordship's convenience, I have different dates. Small dates.
Yes.
Date of occurrence.
Just a minute. Yes.
Date of occurrence on 4/3/2007 at about 4 p.m. FIR registered on the same day, 4/3/2007 at about 5 p.m. 1 hour after. Date of arrest second day, my lord, 5/3/2007. So, and charge was claimed under section 302 and 34 IPC. As per the postmortem report, death was due to decapitation of head from the trunk by means of tangiwa. That is more. Prosecution case is minor on Holy Festival Day, that is on 4/3/2007, at about 4 p.m., when the deceased Nila Naik went to Chandraguru and Jarasingh Guru to demand rupees 500, they getting enraged, abused him. Suddenly, Chandraguru dealt a lathi blow on his belly. As a result, Nila Naik, the deceased, fell down, and Jarasingh, with tangi, dealt blows on his neck, severing the hair from his body, and he died in the spot. And in order to prove the case, prosecution examined 10 witnesses, and the defense examined 3 witnesses.
Yes.
Your man, the informant is PW1, who is the brother of the deceased.
He is the eyewitness.
No, post-occurrence witness.
Gotcha.
Informant is the post-occurrence witness.
Okay.
PW2 is the eyewitness, the wife of the deceased.
Supported the prosecution case.
Minor.
Okay.
After hearing from the death from his sister-in-law, PW2 is the wife of the deceased.
No, PW2, you have mentioned that she is an eyewitness to the occurrence.
Minor.
Our query is that whether she supported the prosecution case or not.
Supported.
Supported. Okay. Next is?
And PW1 was informant.
It's all right, you have stated. Come to PW3.
He is also eyewitness, nephew of the deceased.
Supported the prosecution case.
Minor.
Okay.
PW4 is a Caesar witness. The 5 and 6 are a police constable. And PW7 also a villager eyewitness.
Supported.
Supported.
Okay.
PW8 photographer. PW9 is the doctor who conducted the postmortem. Then PW10 is the investigation officer. And defense has examined 1 to 3 witnesses, which is not necessary in this case because they have only examined for the another accused who is already free from this case.
Okay.
He is not here. Judgment will be after conclusion of trial. The Lawrence additional session judge, both in sessions trial number such and such, has been pleased to convict the appellants under section 302 and 34 IPC and sentenced to undergo RI for life and a fine of rupees 10,000 each to undergo further RI for 2 years.
Okay. Please come to the first information report.
My lord.
That is at page 21 is the relevant page. Come.
My lord.
ପଢନ୍ତୁ
ମହାଶୟ ମୁଁ ଶ୍ରୀ ମନୁ ନାୟକ
ପିତା ସ୍ମରଣ ଶୁଣିବି ଆଜି ଦିନ ହଁ ସେଇଠି ପଢନ୍ତୁ
ଆଜି ଦିନ 4/3/2007 ତାରିଖରେ ଲେଖି ଜଣାଇବାର ରିପୋର୍ଟ ଏହିକି ମୁଁ ଆଜି ଉପର ବେଳେ ବନ୍ଧରେ ଗାଧୋଇ ସାରି ଘରକୁ ଫେରିବା ବେଳେ ଘର ପାଖରେ ମୋର ଭାଉଜ ରଜନୀ ନାୟକ
ରଜନୀ ନାୟକ is PW2. Yes.
ହଁ she is PW2.
Yes.
Wife of the deceased also.
Yes.
ମୋ ଭାଉଜ ରଜନୀ ନାୟକ ସ୍ୱାମୀ ନୀଳ ନାୟକ ଡିସିଜ୍ ମୋତେ କହିଲା କି ଆଜି ଅପରାହ୍ନ ପ୍ରାୟ 4ଟା ବେଳେ ମୋର ଭାଇ ନୀଳ ନାୟକ ମୋର ମାମୁଁ ପୁଅ ଭାଇ ଚନ୍ଦ୍ରଗୁରୁ ଓ ଜରାସିଂ ଗୁରୁ ଜରାସିଂ ଗୁରୁ ଚନ୍ଦ୍ରଗୁରୁ ଦେଇଥିବା ଉଧାରୀ 500 ଟଙ୍କା ସେମାନଙ୍କ ଘର ପାଖରେ ମାଗୁଥିବା ବେଳେ ସେମାନେ ଭୀଷଣ ଗାଡ଼ି ମୋର ଭାଇ ସହିତ ଗାଡ଼ି ଗୁଣ୍ଡସ କଲେ ତେଣୁ ମୋର ଭାଇ ସେଠାରୁ ଆମ ଘରକୁ ଆସିବା ବେଳେ ଆମ ଗାଁ ରାଜୁକଣ୍ଡାର ବିଲରେ ହଠାତ୍ ଚନ୍ଦ୍ରଗୁରୁ ଗୋଟେ ବାଡ଼ିରେ ମୋର ଭାଇର ପେଟକୁ ବାଡ଼େଇ ଦେଲା ତେଣୁ ମୋର ଭାଇ ତଳେ ପଡ଼ିଗଲା ଏହା ଦେଖି ଜରାସିଂ ଗୁରୁ ଧରିଥିବା ଗୋଟେ ଟାଙ୍ଗିରେ ମୋର ଭାଇ ନୀଳ ନାୟକର ବେକକୁ ଭାଙ୍ଗିଦେଲା ତେଣୁ ତାର ଦେହଠାରୁ ବେକ ଅଲଗା ହୋଇଗଲା ଓ ଘଟଣାସ୍ଥଳରେ ମୃତ୍ୟୁ ହେଲା। ଏହା ଦେଖି ମୋର ଭାଉଜ ମୋର ମଣିଷକୁ ହାଣିଦେଲେ ବୋଲି ପାଟି କରି ଡରି ସେଠାରୁ ଘର ଆଡ଼କୁ ଧାଇଁ ଆସିଲା। ସେ ମୋତେ ଏହି ବିଷୟ କହିବାରୁ ମୁଁ ଘଟଣାସ୍ଥଳକୁ ଯାଇ ମୋର ଭାଇ ମରି ପଡ଼ିଥିବା ଦେଖିଲି ଏବଂ ତାର ବେକରେ ଧାରୁଆ ଅସ୍ତ୍ର ଦ୍ୱାରା ହଣା ହୋଇ ତାର ବେକ ଦେହରୁ ସମ୍ପୂର୍ଣ୍ଣ ଅଲଗା ହୋଇଥିବାର ମୁଁ ଦେଖିଲି। ଏହି ବିଷୟ ମଧ୍ୟ ଆମ ଗାଁର ବଳଭଦ୍ର ନାୟକ, ଚିତ୍ତା ଡମଣା ନାୟକ,
Balabhadra Naik is PW7. Then Srikant Naik is PW3. Then Ronko Behera. Ronko Behera not examined. ଅନ୍ୟମାନେ ଦେଖିଛନ୍ତି. Alright, ଅନ୍ୟମାନେ ଦେଖିଛନ୍ତି.
ଆଜ୍ଞା।
So
ଏଇ ମନୋନୟନ ଥିଲା
before going to the evidence of the eyewitnesses, let us come to that doctor's evidence. That is PW9, Dr. Lily Begum.
at page 74.
74.
On 537, I was assistant surgeon, district headquarters hospital, Bauchi. On that day, on police requisition, I conducted the postmortem examination on the dead body of Nilo Naik, son of Madan Naik of Baidyanathapur, under Bounty PS. In connection with Bounty PS case number 22 of 4/3/2007, being identified by Constable number 111 C P.N. Machi, Constable number 130 C S. Pradhan, and Homeguard Bounty PS Maninayak, Bounty PS appeared. Monorail at 1:30 p.m. and found as follows. External appearance: decapitated dead body of a male, 38 years of age, was brought for postmortem examination. There was rigor mortis present in all 4 limbs.
2 is important. One is that injury which is as attributed to the
lathi blow.
lathi blow by lathi blow ta kiye dela first appellant number 1 acha lathi ye hela tangle lines. Okay, so
Cause of death है
decapitation of the head from the trunk leading to profuse bleeding, so on so. Antemortem in nature, postmortem. Then he also stated to have received that weapon for giving his opinion, and on examination of the opinion, one tangia and wooden lathi. So and so you find that the injuries and the disease could have been possible by the weapon of offense. The head was cross-examination. Head was completely severed from the body. I cannot say how many strokes are required to so and so.
To sever the head from the stomach. At the time of postmortem examination, I had also not assessed as to which how many strokes such remnants of head from body can be possible. Tangi and X are 2 different weapons. Normally, X is having shorter staff face than Tangi. When a man, when running, fell down on head on hard surface, he may sustain abrasions or bruises.
That is so far as this injury number 1 is concerned.
Which one? On his bottom. I have not specifically mentioned in my query report as to which of the injuries have been caused by which of the weapon. During my postmortem examination, I found that the stomach of the deceased was empty.
Okay. Now you come to the eyewitness evidence. This you said that one is a post-occurrence witness. So you come to straight to PW2.
The wife of this.
Okay.
I know. That is page 58.
Right.
Yes.
Come. Read it.
I know all the 3 accused persons. Deceased Nilo Naik is my husband. About 10 months back, on the Holy Festival day, after my husband had taken his lunch around 4:30 p.m., he went to the house of Chandra to demand rupees 500. After some time, on hearing the exchange of words, when I went there, saw all the three accused persons were chasing my husband.
Three accused persons mane?
Another brother, but
He has been acquitted, Your Lord.
Acha, acha. Oh, I see. Yes, yes, yes.
Against
yes.
him, the allegation is that he handed over the axe.
Oh, I see. So his name is Mani Ratha Guru. Acha. He has been acquitted of.
3 defense witnesses had been produced on his behalf, Your Lord.
on his
Okay.
behalf.
All right.
For that, he is free.
Okay.
Acquitted.
Pardon.
Chandra dealt a blow lathi on the belly of my husband.
Hmm.
Only one blow. Then
It's all right.
Mani handed over one axe to Jara Singh, who dealt repeated blows with axe on his neck, shivering head from the body.
Hmm.
All through the incidents, I was crying for help. On hearing my cry, Bhadra, Srikanta, Rampo, Bhimo, and Manu came there. Then all the accused persons leaving Lathi at the spot fled away with the axe towards bound running. I can identify the axe with which the accused persons did the blows to my husband. MO1 is the said time. In cross-examination also, she said, I am getting the pension of my husband from Roundless State Bank of India. I am alone getting the pension. The other widow of my husband is living. There was no ill feeling of the accused persons with my husband. The accused persons under the intoxication of liquor for which, on demand of money by my husband, the incident took place. I was present at the spot, short distance from the site of the incident, which is about 8 to 10 feet. Hearing the cry of my husband, I went there along with my son. The houses of Rampo, Timo, Oleu, Nagin, Agui, Gaji, and some others are situated close to the spot. After the incidents, one after the other, the number of persons gathered at the spot. After the people gathered at this spot, I returned to my house and intimated the incidents to my neighbor, Manu Naik, PW1. Then Manu Naik lost FIR. Police has examined me on the way of the incident. It is not a fact that I have not stated that Mani Ratna was present along with the accused persons and participated in the incidents. It is not a fact that Mani Ratna was not present in our village, Kodanathapur, and that he was staying in the village of Pahadapalli in his in-laws' house. In the regular course as well as on that day, it is not a fact that on the relevant day, my husband, in a state of intoxication, went to the house of accused Chandra and demanded rupees 500 as fully expenses, and that when accused Chandra refused, my husband dealt him blow with butt of a gun, and that for that Chandra sustained bleeding injury and fell down senseless, and that then on arrival of Jara Singh, there was a quarrel between my husband and Jara Singh, and that my husband threatened him to kill, and that during the said tussle, my husband sustained injuries and succumbed to it. It is not a fact that I fabricated this case against the accused persons falsely. I have seen the Tangi M1. There is no mark of identification on the said Tangi. Such type of Tangi is available in the village household.
So, what is your comments on this eyewitness who is the widow of the deceased and supposed to have not tell falsehood, leaving the real culprit and implicating somebody falsely? What he has stated against these two appellants, though she implicated one Manira, right? But since that is right, and also he has also not implicated perhaps him in the previous statement. That is why this confrontation was made also, and maybe that was found to be correct, and So there was no material against that particular accused. He has been acquitted. But so far as these two appellants are concerned, of course, against the Chandra Guru, that is appellant number 1,
He
the
already dealt one lathi.
lathi blow, and that was on the abdomen portion. He has not repeated it. But how do you demolish this evidence, whatever he has stated against so far as this appellant number 2, particularly Jara Singh Guru, and coupled with the post-mortem report, the doctor's evidence which you just placed, that it completely severing the head from the trunk and possibility of the injury with such acts as has been opined.
But I humbly said, my lord, they are the OP number PW21 has stated, your lordship, I will read that they used to drink liquor because that was a festival day. And this person, I am reading that proceedings and page constitution by the PW1. Detail for the whole.
No, what do you mean by say liquor they used to take in during festive season, even otherwise?
So the deceased and the accused.
No, it's all right. They used to take liquor. That may be they. But how merely because they took liquor on that day, and it was a festive day. Of course, on Holi, during Holi festival, this thing has happened. How do you say that on that account merely because they have taken liquor? All of them, let us say, appellants have consumed liquor, so also the deceased. How that would demolish the evidence of this PW2? The manner in which she has narrated the entire incident, and the distance from which she had seen the occurrence, and coupled with the time of occurrence, all these factors, and perhaps the other two eyewitnesses, as you stated in your note, they have also corroborated the evidence of this PW2. You said in your note that two other eyewitnesses are there. One is PW3, the other is PW7. And they have also stated in the like manner.
Yes,
All right, come to then, let us finish all those three and then go to the other part. You place the PW3 and then you place PW7.
yes, ma'am. PW3. I know the accused persons who are standing in the dock today. The informant Manu Naik, deceased Nura Naik is my father's elder brother. About 9 months back on the Holi festival day, after playing Holi and taking our meals, when I came out, I had Hala, but that time Rajani Naik elder brother's wife was also present behind me.
Rajani is PW2.
Yes. The wife of the deceased.
Yes, that is PW2.
On hearing that Hala, myself and Rajani, wife of Nira, rushed there and saw that the accused persons Jora Chandra and Maniratnam were chasing Niramani with lathi and tangia in their hands. All of a sudden, when Niramani turned back, Chandra dealt a lathi blow on his belly, and as he fell down, Mani handed over the tangi to the Jora, exhorted to kill Nira, and then Jora dealt 3 to 4 blows on the neck of Niramani. As a result, the head of the Niramani severed from his body, at which I raised fire. The accused persons living on Lathi fled away with the tangi towards Bounce. Cross the general my elder father, Niramani, used to taste liquor. By the time I returned home after playing fully, it was about 4 p.m. During the period of assault, we are staying at a distance of half a kilometer from the spot from the deceased. Near the place of occurrence, there are houses of Romsko, Protap, Bhimo, and Vadi. Prior to the occurrence, I had not gone to the house of my elder mother, Rajani. At the time of occurrence, besides my elder mother, Rajani, other villagers, namely Dibosa Naik, Romsko Behela, Protap Naik, some others, at a short distance behind me. When I saw the incident, accused persons were chasing Nilamani, that is, from their house, and while running away, he trembled. He might be the fact that while chasing the deceased, he turned back with a hope that at our side, accused Jara dealt 3 to 4 blows with Tangi on Nilamani at his leg. All the said Tangi blows were dealt after he said he lay down on the ground. The incident took place on the vacant paddy land. We all were following went to the spot almost jointly. The chopped head was lying at a distance of 2 to 4 cubic away from the spot. There was no jumping of the separate portion of the body or head at the spot.
তো এই जो particular line টা କହିଲା paragraph page 62 रे, when I saw the incident, Mr. Mishra, please mark it.
Gotcha.
When I saw the incident, the accused persons were chasing Nilaman from their house, right?
Yes.
And while running away, he stumbled down.
Yes.
Stumbled down. That the doctor says, just keep in mind that the injury on the abdomen, say you onanti
Might be
lathita,
possible.
it is also possible by that due to fall. है ना?
Yes.
So it might be a fact that while chasing the deceased, he turned back with a hope to get courage from one side. Accused Jara dealt 3 to 4 lathi blows once. So all these said tangy blows once. So a possibility of that injury due to fall, because he has stated about that, cannot be ruled out also. But so far as this accused is concerned, Jarasing Guru, by means of Tangia, that is almost consistent between these two witnesses and so also the doctor's evidence. Chopped wound was lying at a so-and-so distance. Okay, now you come to the last eyewitness, as you mentioned in your written note, that PW7, na?
PW7.
Balabhadra.
Balabhadra Naik.
I know the accused persons on the day of last Holy Festival around 3:30 p.m. to 4 p.m. While I was in village street, I had some halla from the land of Raju Ponda, which is 30 to 40 km away from the place where I was present. By then, on going there, I saw Chandra, Jora, and Moninath. While chasing during night, Chandra dealt a lathi blow on his stomach. As a result, he fell down. Then Moninath, exhorting to kill Nila, handed over the tangi to Jara, who then dealt 3 to 4 tangi blows on the neck of the Nila, severing the head from his body. In spite of my protest, although also the incident, then Chandra, leaving the lathi was with which he had assaulted Nila at the spot, fled away with the tangi.
Read the cross-examination.
Expert Chandra and other 2 accused persons, Nila from the house of accused Chandra towards that of the house of. While Nila the deceased was being chased, he was shouting as Morigoli, Morigoli. And on hearing the cry, I went there and saw the entire incident. I first rushed to the spot. Then Rajini arrived there, followed by others after my arrival at the spot. The accused person started attacking the deceased hero. Besides myself
Myself and Rajani.
some others, in total 8 to 10 persons have
Seen the incident.
seen the incident of attack on deceased mirror. We all the witnesses had watched the incident at a distance of 15 to 20 kilometers away. Thus far, I cannot say any injury on the accused persons at the time of attack on the mirror. I do not know if accused Chandra on the same day sustained head injury and was hospitalized for the injury.
Any doctor has been examined or any medical document proved?
About the health of Chandra.
Chandra, yes.
About the health of the about that you have taken a defense plea perhaps that during the course of occurrence the appellant number 1 Chandra Guru was assaulted
By the deceased.
right, but
in T13 statement, accused statement, he has told all this.
no
No.
ଆମ ପ୍ରଶ୍ନଟା ଆମର ହଉଛି ଯେ ସିଏ ଯୋଉ assault ହେଇଥିଲା ବୋଲି କୌଣସି medical evidence
ଆଗେ ଆସିଲା କି ଡିଫେନ୍ସ ଯେହେତୁ ଦେଇଛନ୍ତି
No example.
no medical
Only the IO has stated, your lordship.
Can't hold
One
it.
sentence he has stated that in his cross,
huh?
that accused Chandra sustained injuries due to pelting of stones by the deceased, but I have not instituted any counter case. That is the only thing. That's at page 80 and 81. The last.
No, has he sent him to any hospital for medical?
in the cross examination he has stated, no?
Okay.
Yes, he had sent,
10.
your lordship. He has
Double
stated
10.
that. IO has stated that accused Chandra Guru was injured during
just a minute. Just a minute. Page 81.
Page 80, your lordship.
80, huh?
Cross of the IO.
Accused Chandra Guru was injured during the relevant period for which I issued requisition for his medical examination. Accused Chandra sustained injuries due to pelting of stones by the deceased, but I have not instituted any counter case. So, ଏଇ ଜିନିଷଟାକୁ ଯଦି ଆମେ ଧରିବା either let us say fall ରେ ବି ହେଇପାରିବ, otherwise ଯଦି ଏଇଆ version ଆସୁଛି ଯୋଉ appellant number 1 ନାରେ ତାକୁ ଇଏ ଟେକା ପକେଇଲା ତାପରେ ଧର ବି ଗୋଟେ ବାଡି ପାହାରଟେ ଦେଇଛି ସେ ଯୋଉ ଇଏରେ ତାର how can you say that he has common intention with the other appellant who has dealt Tangia blow repeatedly on the neck and severed it, because the conviction is for life imprisonment 302/34. Your case is just dealt one blow as per the lathi on the abdomen. Injury gote abrasion asuchi. Whereas doctor's evidence asuchi je due to fall such injury can be possible, and evidence further asuchi je that man orthat appellant number 1 was also attacked by the deceased. He was ଯାହା ବି ହଉ ଇଞ୍ଜୁରି ମଧ୍ୟ ସିଏ ଦେଖିଥିଲା କିନ୍ତୁ କାଉଣ୍ଟର କେସ୍ କିଛି ଇନଷ୍ଟିଚ୍ୟୁଟ କରିନଥିଲା, ସେ ବିଷୟରେ ମଧ୍ୟ ଏଭିଡେନ୍ସ ଆସୁଛି। ତେଣୁ ଏଇ ସର୍କମଷ୍ଟାନ୍ସରେ ହଁ ବ୍ୟାକଗ୍ରାଉଣ୍ଡଟା ଦେଖନ୍ତୁ, ସିଏ ଯାଉଥିଲେ ବ୍ୟାକଗ୍ରାଉଣ୍ଡଟା ହଉଛି ସେ ଯୋଉ ହୋଲି ପାଇଁ ଇଏ ଯାଇକିନି ଡିସିଜ୍ଡ ଯାଇକିନି ତାଙ୍କୁ ମାଗିଛି 500 ଟଙ୍କା ଦିଅ, ଯୋଉଟାକୁ ଯୋଉଥି ନେଇକିନି ଗଣ୍ଡଗୋଳ ହେଇଛି। ଗଣ୍ଡଗୋଳ ହେଇକିନି ଦୌଡା ଦୌଡି ହେଇଛନ୍ତି, ତା ଭିତରେ ଇଏ ତାକୁ ଡିସିଜ୍ ଟେକା ମାରିଛି, ଇଏ ଯଦି ବି ହୁଏ ଗୋଟେ ତାରି ଭିତରେ ଗୋଟେ ବାଡିଟେ ବାଡି ଦେଇଛି ତାର ଇଏ, but the main allegation seems to be against Jara Singh.
Sudden provocation is
So, madam, there is no escape from 302 for this appellant number 2, Jara Singh Gur, as it prima facie appears, because it is due to his repeated blows by Tangia, that to on a vital part of the body, the head of the.
Severance.
Huh?
There is severance
Ah.
of.
And blood patches have also been found on both the accused. In fact.
Tangia was
No,
also
that is
seized.
Yes. consistent. That is
Ah.
consistent.
And this Tangia also contained blood that is
of
also
human
as per
origin, Your
this,
Lordship.
huh?
Of human origin.
The only thing to be seen whether he has shared the intention, because
See,
Chandra had also chased.
Yes.
After he chased only, this has come. Chased, but someone has stated that he fell down, stumbled down. So whether there was a lathi blow based out of which he fell down, or he was stumbled, that is how Chandra's case is a matter to be seen, examined. But the other case is consistent. Decapitation of
as
body.
it appears, his case, as
My lords.
my esteemed brother pointed out, that the case of this appellant number 1, that stands in a different footing than this appellant number 2, because the only accusation about the giving of that lathi blow on the abdomen portion stated to have caused that abrasion, but which is otherwise possible, that is due to fall, and the evidence appears on record through your eyewitnesses that in fact the deceased during chasing the fell down, and perhaps after falling down, he also threw some bricks at the for which this appellant number 1 sustained injury. In that scenario, suppose after being thrown with the brick bats and sustaining injury, he dealt one blow with that lathi. Can it be said that he shared common intention with the other appellant, that is
To
Jara
cause
Singh,
murder.
to commit murder of him? And think of it that he has not repeated the blow. Only
one blow.
your case is only one.
The conduct before the incident is only that he chased them.
That is what we
By that time, even the prosecution has not established that these two persons were in fact chasing for killing, because our case is that Mani was the one who handed over the axe. He was the one.
ପ୍ରଥମରୁ ମଧ୍ୟ ଏମାନେ ଯୋଉ ଦି ଜଣଙ୍କ ହାତରେ, ମାନେ ୟା ହାତରେ ବି ଆକ୍ସ ନଥିଲା, ଆପଣ କେସ୍ ଯାହା ତେଣୁ ଚେଜ୍ ହଉଥିଲା, ଚେଜିଂ ୱାଜ ଦେୟାର, ଚେଜିଂ ବେଳେ ଆପଣଙ୍କର ଏଭିଡେନ୍ସ ଆସୁଛି ସେ ପଡିଗଲା ପରେ, ଏବଂ ଇଏ ଯାହା ଏଭିଡେନ୍ସ ଆସୁଛି ଯେ ଦେयर ୱାଜ ସମ୍ କାଇଣ୍ଡ ଅଫ few of brickbats, ଗୋଟା ସେ ବି ଯାହା ବି injury ସେ sustain କରିଛି, but there is no case, no medical evidence, but the IO says that I have noticed some injury. But এই background ରେ ଯଦି ଦେଖିବା ତାହେଲେ how it can be said that he shared common intention to commit murder. Preconcept of mind ର ଏଠି ନାହିଁ, କାରଣ ସେମାନେ ପ୍ରିପେୟାର୍ଡ ହେଇକିନି ଆସିନାହାନ୍ତି scene of occurrence କୁ with ଲାଠି, ମନେକର ସେଇ ଜିନିଷଟା ଦି ଜଣ ଯାକ ଧରିକିନି ଆସିଥାନ୍ତି, ଏକାଠି ସାଙ୍ଗ ହେଇକିନି ଆସିଥାନ୍ତେ ଆକୁ ଇଏ କରିବା ପାଇଁ, matter would have been different. But here ଗୋଟେ ଇଏ ଯାଇକିନି ତାଙ୍କୁ ମାଗିଛି ଟଙ୍କା, ମାଗିକିନି ଇଏ ମନା କରିଛନ୍ତି, ଗୋଟେ କ୍ୱାରଲ ହେଇଛି, ତାପରେ ଇଏ ବୋଧେ ତାକୁ ଚେସ୍ କରିଛନ୍ତି, ତାକୁ ଯାହା ଆସୁଛି ଆପଣଙ୍କର ଏଭିଡେନ୍ସ, ଚେସ୍ କଲା ବେଳେ ସେ ପଡି ଯାଇଛି, ପଡିଲା ପରେ assault ଯାହା ହେଇଛି, ସେ ପର୍ଯ୍ୟନ୍ତ ମଧ୍ୟ ୟା ପାଖରେ ଆପଣଙ୍କର ଏଭିଡେନ୍ସ ଅଛି ଯେ he was not holding any weapon. ଦେ ଯୋଉ ନମ୍ବର 2 ଟା ହେଲା, ଇ ପଡିଗଲା ପରେ ତାକୁ ସିଏ ହ୍ୟାଣ୍ଡ ଓଭର କରିକିନି abatement କରିଛି, ଯୋଉଟା କି he has been acquitted of. So ଏଇ circumstance ରେ what would be the liability of
Chandra
ସେଗୁଟା କଣ?
One more aspect is, Your Lordship, the chemical examination report. In the lathi also blood patches have been found, and that is deep, Your Lordship. The observation is deep blood patches have been found. So even though none of the witnesses have seen that he giving repeated blows, but somehow
after suppose let us say ଆପଣଙ୍କର case ଟା ବି accept ହବ, ଧର सी ताकू गोटे एब्डोमेन पोर्शन ने गोटे ब्लो देला सेथुरु ब्लड धरिबा ता देहरे आसीबार संभावना बहुत कम कारण तापरे असॉल्ट हेची तापरे नेक हेची से सेते बेले ब्लड फ्लड आस्तिबो तापरे किछि नाही मे बी दैट से लाठी कोड जबत हेची स्पॉट रू
लाठी
was left on the spot
सेती बेले जो रक्त लागिथिबो सेतले पकेई देकिन जाईथिबो सेठी हुए तो माने सेईटू ब्लड लागिथि कारण आपनर केस ही नुह जे आउ ता उपरे लाठी रे आउ कोनोसी रिपीटेड असॉल्ट हेची बाय तेणु जो आपण कहउचंदी लाठी रे रक्तटा मे बी दैट आफ्टर she was assaulted with that tangia by this appellant number 2 for which there may be profuse bleeding because the vital neck was severe तेणु सेही circumstance रे लाठी जदी पकेइकिन जणे आसीथिबो तेणु the possibility is there that
rather that way if you see he has been acquitted but money has shared by giving the tangia to the person who killed.
But the defense caused reasonable doubt by 3 witnesses stating that he was not in that village at the point of time. That is why he has been acquitted at the time. But blood patches have been found in both the wearing apparels, which have been seized before in India by in the presence. In both your lordship, both the accused who are before your lordship, both of them. Although the blood group has not been identified, but it has been identified that they are both of human origin. So even though appellant number 1 who was holding a lathi might not have attacked, he could have gotten the blood patches because the other accused person was blood splatter.
जोरे मारदेले तब से ही जागारू वेल्स गुडा कटिकिन छिटकिन पड़िबार पॉसिबिलिटी जाऊ ऑब्वियसली स्पॉट रे तो पड़ियो तो लाठी तो एकदम सेठी पकेई देला माने पॉसिबिलिटी रहउची लाठी
Yes, your lordship.
But in 313 statement of the accused, ସେତେବେଳେ ସେ ଲେଖିଛି ଆଗ ସେ ତାର ବନ୍ଧୁକରେ ତାକୁ ବାଡେଇଲା ଯାହା ଫଳରେ
ଆପଣଙ୍କର ଟୋଟାଲ କିଛି କେସ୍ ହିଁ ନାହିଁ ଆପଣଙ୍କର एक तो ଆପଣଙ୍କର ଏଫଆଇଆର ନାହିଁ କିଛି इंजुरी ନାହିଁ ଖାଲି आईओ କହୁଛି इंजुरी अछि जदि भी ताकू ग्रहण करागले ଆପଣଙ୍କର डिफेंस प्ली is required to be even established by preponderance of probability এই जो प्ली आपण नेइछन let us come to that आपण जो हार्प करूछन let us come to that particular plea which you have taken come to page 53 कोन नेइछन कहले आपण आपसे accused ना कोन कोड से प्ली नहीं चंदी आपनकर 313 स्टेटमेंट
313 द at page 35 से निजे जहा कहछि
35
पढ़ना दी कोन
35 पेज रे
एटा कहार अक्यूज स्टेटमेंट 35 रे
चंद्रगुरु
चंद्र माने अपलाइन नंबर 1 हां कोन हला आपन
पेज 35
हां क्वेश्चन नंबर 41 को सीधा पळे आसन
फगुण पूर्णिमा दिन नीलनायक मद खाई आम घर को
नीलनायक माने डिसीज हला
हां 2 दिन जाईछि एटा माने जजमेंट रे नाही
पढन
को आसी पार्टीतुंड कले से मोर बड़ भाई हिसाब रे हेबारु आमे किछि कहिलु नाही ता पर दिन यथा होली दिन से होली खेली मद भाटी को गला दिन 3टा समय रे आम घर को आसी मोते 500 टंका मागी मु न देबारु मोते धरिथिबा बंधु करे मुंडरे पिटी देला एवं मोर मुंड फाटी मु तळे पड़ी गली ओ मोर चेता बुडी गला मोर चेता आसीबा परे मु थाना को एतला देबा को गली आ किछि जानि नै in the judgment my lord this thing has been ignored
no apno
no that is it's only a statement quality but 315 has not been followed
apno you are the competent witness you could have examined yourself in court to substantiate that ଆପଣଙ୍କର ଇଏ କୁ ଖାଲି ଗୋଟେ ପ୍ଲି ତ ନେଇଗଲେ ହବନି ତ ତାକୁ ଏଷ୍ଟାବ୍ଲିଶ କରିବା ପାଇଁ ସେଇ ଷ୍ଟାଣ୍ଡାର୍ଡ ଦରକାର ନାହିଁ ମାନେ ଯୋଉ ପ୍ରୋସିକ୍ୟୁସନ ର ଯୋଉ ବିୟଣ୍ଡ ଅଲ ରିଜନେବଲ ଡାଉଟ ସେଇଟା ଦରକାର ନାହିଁ ବଟ୍ କିଛି ତ ଆଣିବେ ଯୋଉଥିରୁ କି ଆପଣଙ୍କର ଏ ପ୍ଲି ଟା ଏଷ୍ଟାବ୍ଲିଶ ହବ ମାନେ ଇଭେନ ଇଫ ବାଇ ୱେ ଅଫ କ୍ରସ୍ ଏକ୍ସାମିନେସନ ଅଫ ଦି ପ୍ରୋସିକ୍ୟୁସନ ୱିଟନେସେସ୍ ତା ଦେହରୁ ଯଦି କିଛି ଆଣିଥାନ୍ତେ ଯୋଉଟା କି କରୋବୋରେଟ କରିଥାନ୍ତା
Otherwise, the presumption has to be there that an accused, why 313 is not taken on oath? 313 is not taken on oath. So it is expected that an accused has an inherent right to tell lie unless 315 comes.
And no gun was also seized after the incident. So these are two separate incidents. So taking that as grave and sudden provocation from a previous incident, that begs no consideration, Your Lordship.
And these two eyewitnesses, that defense plea has not been even suggested to PW 3 and 7. It is suggested to PW 2, of course, that about this gone thing has been perhaps passed on only that the accused refused to pay so and so, but of the gone and Chandra sustained flooding fell down. Okay. And that then after the arrival of Jarsing there was quarrel between so and so, this one. ଆପଣ ଯୋଉ ସଜେସନ ଟା ଦେଇନାହାନ୍ତି ଆପଣ ଡିଫେନ୍ସ ପ୍ଲିଟା ଯୋଉଟା ନେଇଛନ୍ତି ଯୋଉ 313 ଆମକୁ ପଢି ଶୁଣେଇଲେ ଆଇ ୱିଟନେସ୍ ମାନଙ୍କୁ ତିନିଟା ଆଇ ୱିଟନେସ୍ 3 ଆଉ 7 କୁ ସେ ବିଷୟରେ କିଛି କନଫ୍ରଣ୍ଟ ହେଇନି ସଜେସନ ଆଚ୍ଛା PW2 କୁ ଯୋଉ କନଫ୍ରଣ୍ଟେସନ ହେଇଛନ୍ତି ସେଇଟାକୁ ଆସନ୍ତୁ ଆପଣ ଯେ ସେ ଯୋଉ ଡିଫେନ୍ସ ପ୍ଲି ସଜେଷ୍ଟ କରିଛନ୍ତି ଆପଣ ପଳେଇ ଆସନ୍ତୁ ସେଠି ପେଜ ନମ୍ବର 59 ର ଏଣ୍ଡ କୁ ଆସନ୍ତୁ it's not a fact. Please come to the last line. It is not a fact that page 59.
It is not a fact that the Paniratha was not present in our village.
No, you come to the last line. It is not a fact. Come to the next page. On the relevant day, my husband in a state of intoxication. Page 60.
Relevant day, my husband in a state was not. My husband in a state of intoxication went to the house of Arti Chandra and demanded rupees 500 as holy expenses. And that when accused Chandra refused my husband, dealt him blow with pot of gun. Chandra sustained bleeding injury and fell down senseless. And that then on arrival of Jara Singh, there was quarrel between my husband and Jara Singh. And that my husband threatened him to kill. And that during the said tussle, my husband sustained injuries and succumbed to it.
This latter part is not the plea of Jara Singh. Jara Singh accused statement ଦେଖୁନାହାନ୍ତି ଆପଣଙ୍କର ଗୋଟେ ଯୋଉ ପ୍ଲିଟା ନେଲେ ଆପଣଙ୍କର ପ୍ଲିଟା କୁ ପାର୍ଟଲି କନଫ୍ରଣ୍ଟ ହେଲା ଗୋଟିଏ ଆଇ ୱିଟନେସ୍ କୁ ମାନେ ସଜେସନ ଦିଆଗଲା whereas ସେଇ ପ୍ଲିରେ ଆଉ ଗୋଟେ ପାର୍ଟ ରହୁଛି ଯେ କେମିତି deceased sustained injury ହେଲା now you come that relates to that Jara Singh ର ଆସିଲା ଆପଣ accused statement Jara Singh ର ଅଛି page 44 ଦିନ 44 ରେ final question
ମୁଁ କିଛି ଜାଣିନି
ହୋଲି ଦିନ କଣ ହେଲା ମୁଁ ଜାଣିନି ସେ ତ କିଛି କହୁନି କଳି ହେଲା ଇଏ ହେଲା ଏମିତି ଆସିଲେ
ଭାଇ ସାଥିରେ ଝାମେଲା କରିଥିଲେ ହୋଲି ଦିନ ସେ କଣ ହେଲା ମୁଁ ଜାଣିନି ଯେହେତୁ ସେଇ ସମୟରେ ମୁଁ ପିଲା ଛୁଆଙ୍କୁ ନେଇ ଘରେ ଶୋଇଥିଲି
So your defense plea is not consistent. It has not been suggested to the eyewitnesses, nor you have adduced any evidence. The best witness, also competent witness, is the accused under 315 CRPC. You have not examined yourself. No FIR from your side. No injury report. So how can you establish a right of private defense plea if at all it is your case? Standard of proof, it's all like that you can establish it preponderance of probabilities, but something is to be brought on record to take into account that. Anything you want to further argue, Mrs. Das?
No.
Okay. Yes, Mr.
Lordship.
Mishra.
Lordship has seen the post-mortem report.
Yeah.
My humble submission is that so far as the second appellant is concerned, it is crystal clear that he was there. 3 witnesses have seen him, and he in fact dealt as many as axe blows as it is needed by that particular weapon to behead a person, Your Lordship. Now, Your Lordship, so far as the other appellant is concerned,
that Tangia blow is corroborated by the PM report,
report, Your Lordship. And all the 3 witnesses have seen the appellant number 2 holding the Tangia and giving the blows, Your Lordship. The number of blows have not been stated, but I don't think that would be relevant because in such a heat of a moment, it's very difficult. Even though PW3 has stated that it was 3 to 4 blows. And so far as the common intention of the
and
other,
that Tangia was also sent, and it
yes,
as per the C report, it contains
blood, Your Lordship. It contains blood of human origin that has been detected, Your Lordship.
C human blood in Tangia. Yes.
Now, Your Lordship, so far as the other appellant is concerned, the conduct has to be seen before the incident. Now, it's crystal clear that there was some dispute going on at that very moment between 500 rupees. Lordship, the allegation is that he asked them for 500 rupees. After that, some quarrel ensued between them, and then they chased them. 3 of them were chasing. That is the case of the prosecution. One of the accused has been acquitted already. So the case of the prosecution is that while chasing, the person who has been acquitted was holding the axe, and the rest 2 accused persons, one was holding a lathi, that is appellant number 1, and appellant number 2 was chasing without any weapon. Now, as to what happened, how he fell exactly, there are 2 versions which are coming out. One version is that PW2 and PW7 have stated that the deceased turned around, gaining confidence by looking at them, and then appellant number 1 dealt a lathi blow to the stomach, and after that he fell down. PW3 in his cross has stated that he stumbled down and fell.
Without
any lathi blow.
So he stumbled down, and the doctor says that the possibility is there. That you abrasion ta heichi seta podile ei paribo boli.
Lordship. But the doctor has also stated that these weapons, that is the lathi and the axe which were produced, are also capable of giving that injury.
No, so apanakar jo 34 one of the vital thing required about the preconcert of mind.
Yes, Lordship.
Ethi preconcert of mind to commit the murder. Ethi आकु केमती आनिबे हमर जो आपण appellant number 1 नारे जहा आपण ओवरटैक आनिछन ता द्वारा he shared common intention with the appellant number 2 ए जिंसटा केमती आनिबे.
Because the conduct part, Your Lordship, that they were both chasing the accused.
नहीं जणे आसिकिनी मद पीकिनी कहयाकु 500 टका या मद पीवा पई तो ना मद पीकिनी आसला PW
after being intoxicated.
हाँ मद पीकिनी जणे आसी तांकु 500 टका मागुची बोली आपन एविडेंस यूज या जे 500 टका आसिला मागिला ना. What is the evidence?
Yes, 500 rupees.
500 rupees. तो जणे मद पीकिनी घर पाको आसियो 500 टका मागियो ये ता सारे कॉल करो ताको पळा ये जीवनी दौड़ीबे ता पछरे एही सर्कमस्टांस रे if he is holding a lathi villagers को हाथ रे लाठी टा गोटे केमती गोटे unusual feature नुहे आउ सेही सर्कमस्टांस रे जल्दी से दौड़ीची ता पछरे आ गोटे रिपीट करूनी ब्लो गोटे ब्लो देइची ता पेटो को जदी आपनकर केस भी एक्सेप्ट हुए नाइ से सेटा पडिवा द्वारा हेइनी या भी जदी हुए सो stretching it to that sharing of common intention to commit murder is very difficult to come to that subject to hurt my esteemed brothers.
That is also there because that was not the intention that we can expect from the accused persons. It started only when the deceased came here and demanded the money. There was nothing of the sort that an altercation took place at the behest of the accused persons that turned into this. So here the question of common intention, sharing common intention has to be seen very seriously. Reason being, after being chased, if at all we accept, as my learned brother was saying, a blow is there. So that cannot be taken as a sharing of the common intention, unlike 149, where we normally go that who does what is not the question. Common object is different. It's common. So if at all we accept that yes, there was a blow, it was not intended to see that the person is to be murdered. Neither it was there germinated at the very inception, nor it happened at this spot. It is a subsequent event.
Yes, his act is totally different. With this appellant number two's overt committed, maybe that whether the weapon was there or not in his hand or it was handed over to him. So by that time, even the weapon was not there. ଆପଣଙ୍କର case ଯଦି ବି ଦିଆଯାଏ, ତେଣୁ ସେଠି
So it is one and one person.
Right.
Section 34 not attractive.
Right. That is. The Mrs. Meena Kumari Das, appellant, and Mr. Shonak Mishra, Learning Counsel for the state. Hearing is closed, judgment is reserved.
Okay.
Sorry. So, Mr. Mishra, that's all for today. Gotcha.
My lord, my lord, the interim application for modification is infructuous, my lord.
All right. IA number so and so. There is an application for modification of the order dated so and so. The Land and Council for the petitioner submits that the interim application has become infructuous. In view of such submission, IA stands disposed of. Yeah.
Once earlier rejected by your lordship and another Pradhan Jani matter. I pray your lordship may direct the registry to list the matter as per the Pradhan Jani in fresh, my lord. Pradhan Jani decision अनुजाई जो matter your lordship has coming to your lordship board, my lord, that may be separately listed, my lord. Since that was, my lord, your lordship has allowed the bail application, for that reason the matter was come to your lordship. My two matters are there, my lord. One 379 and 399, my lord. Okay. Your lordship has co-accused person.
Yes, Mr. Pujari.
PLPL number 8683 of 2022. This matter was in the list prior to vacation.
8683.
Of 22. Same case number today is at serial number 2.
Another matter has come.
Anything
you file it, it will come next week. Today it cannot be listed, but memo receive karo.
Item 181, my lord. Modification for extension, my lord. 181, my lord.
181.
My lord.
How many times you have taken extension?
First, my lord.
First extension.
My lord.
On 81, na?
My lord.
That is ABLAPL number 2827.
My lord.
So it is extended till end of November. Okay.
My lord.
I disposed of. Yes.
My lord, may I mention BAPL number 12446 of 2023? My lord, in this matter, petitioner is in JC since March 2021, and 4 co-accused are already on bail, my lord. The father of the petitioner is suffering from cancer. He is on dead bed, my lord. I humbly praying, my lord, kindly list it on
Madam, it
supplement.
has been noted down. It will come next week, okay?
Oblige, my lord.
My lord, item 87, a tied up matter. Last 2 months it is in list but doesn't reach my lord.
Okay. See that. Yes, all the matters.
Beg your pardon, my lord. Item 217 is juvenile bail, your lords. 217 out of 11, around 10 months in custody. The main accused, 13 years boy. 277.
My lord, beg your pardon, lordship. Item 175. It's in a Belgium matter, lordship. The accused is in the jail custody since 25/9. 175, lordship.
75.
Supplementary list, item number 1.
Wait.
My lord. My lord.
Have your patience.
It's a tied up matter, lordship. Earlier passed in a bail order, lordship, and pursuant to a warrant, he has been arrested on 25/9, your lordship.
So, where is the rejection order?
My lord, the rejection order is under Annexure 5, your lordship. Annexure 5.
You are in custody since 25/9/23.
My lords.
He was on bail due to non-taking of steps non-bail in warrant of arrest. Pursuant to which warrant he was taken into custody since 25/9/2023. Baki Belgium format 3 allowed it. Allowed it.
Obliged, my lord.
One kete violator. 175. All right. Yes.
My lord, I'm mentioning the bail application number 10781. My lord, the petitioner is in the JC for 3 years and all the accused are on bail.
All right, check down the number.
Sir, kindly list the matter in the supplementary list.
10781 of 23. All right, madam, it will come next week in the next Friday. Yeah.
Nice.
Supplementary list, item number 1.
May I please your lordship? And the petitioner was an accused under section 419, 420, 467, 468 and 471, 120B IPC. Was arrested and after his bail application was rejected, he has filed this application for bail before your lordship. And your lordship, while deciding the application for bail, found that there are some misappropriations, since there are some allegations of misappropriations, and an amount of rupees 73 lakhs was found in our account, my lord. The lordship directed to deposit the 73 lakhs in 3 monthly installment and to be released on bail. He has already deposited, my lord, 46 lakhs. The rest amount, my lord, he is unable to deposit, my lord. Lordship has permitted me to.
No, that has been already, once it has been modified.
Yes.
It instead of 3, it has been made to 6 equal months.
With much difficulty, he has paid. After modification, he has paid, my lord, some amount. Now he has not a single pie, my lord. The lordship has directed to convert to property security.
How much amount you have deposited?
I have already deposited, my 46 lakhs.
So where is the documentary proof to that effect? Where is the deposit proof? Or where is the order of the land and trial court?
Next, my lord.
Yes.
So total ta nahi, last, my lord, page 3. Last, my lord. Last page of the brief. Last page of the petition, my lord. The case record is put up today as the loan.
That is only for 9,12,778.
Yes.
So what about the other amount?
This was the last installment, my lord. If the entire amount which I have paid, I will file an affidavit by tomorrow, my lord.
No, once have you taken averment?
Yes. Yes.
In which paragraph?
Second modification for it, first modification for it.
The present petitioner paid an amount of rupees.
Para 6, my lord.
Para 6.
And thereafter, the present petitioner has paid 3 months installment. That is after second modification, my lord. When your lordship directed the
First modification.
first modification, my lord.
So instruction to be obtained from which court it is?
PID court.
All right, Mr. Dharanjan Naik, land modification of the order dated so on so. Land Council submits that the petitioner was directed to be released on bail as per order dated 16/5/2023. Imperative with the condition that the petitioner shall furnish cash security of 25% of the amount credited to his account as per letter dated 9/5/2023 received from Inspector of Police EOW CIDCB Bhubaneswar at the time of his release on bail, and given undertaking to deposit the balance amount in 3 equal monthly installments. The Land Council further submitted that the said order was modified in IA number 896 of 2023 as per order dated 4/7/2023. And instead of 3 equal monthly installment, the petitioner was directed to deposit the balance amount in 6 equal monthly installments. Mr. Naik submitted that the petitioner has deposited all total 46 lakhs by now, and is at present in financial difficulty.
About 46
Huh?
Exact 46 no 45 something about 46.
About 46 lakhs by now, and is on account of his financial difficulty is unable to deposit the rest of the amount, and the petitioner is ready and willing to furnish property security. However, no documentary proof has been submitted before this court relating to the deposit made. In view of such circumstances, let a report be called for from the Lennon First Additional Session Judge cum Special Judge Vigilance Bhubaneswar. No, it is pending in the court of SDGM Khurda.
No, my lord. Now case has been transferred to OPID court Cuttack.
Asha. So, presiding officer, OPID court, Cuttack. In what is the case number?
CT case number 6256 of 2022.
City case number
6256.
6256 of 2022. Presiding officer, designated court OPID Act, Katakala, which arises out of EOW Bhubaneswar PS case number 19 of 2022. To how much amount the petitioner has deposited as per the bail order dated 16/5/2023. Matter be placed before the London Register Judicial, who shall send an email by usual order for the report to be received, sent to this court on or before 8th of November 2023. Matter be listed on 10th November 2023. Yes.
Till then, no coercive action, man.
On Nihalani.
Kali date achi kale puni. Regular deiju. Next installment another they may take me custody, my lord.
What is the next date of installment?
Tomorrow.
It is stated at the bar that the next date of payment of installment is fixed to tomorrow. No coercive action shall be taken till next date in case the petitioner fails to deposit the installment amount tomorrow. Yes.
Urgent certified copy.
Yes. Yes, Mr. Chan.
Item 2.
Case under section 147, 148, 302, 120B, 149.
Milord, item 2 kindly be taken up along with weekly list item 24. The CD file is there, Milord. Item 24.
Yes, ma'am. CD is there. Okay. 24 also is
Right.
Argo the matter.
It's a case, my lord, it's a double murder case. And in the meantime, my lord is kind enough to grant bail to 2 co-accused persons. And so far,
so far as this petitioner is concerned,
he has not been named in the affair.
No, he has come for the first time or
First time. No. It is for the second time, my lord. It was before this on court and it was disposed of in BLFL number 2764 of 2021.
Just a minute. Here the petitioner is one or
only one, my lord. One.
BLFL 941/2023 Rania alias Ranjit Pradhan. So this petitioner, what is the date of custody?
My lord, he is in taken custody from 11/1/2021. 11/1/2021.
And what is the connected matter? Mr. Tripathi said 24 minutes. 24. There are 2 matters. There are 1, 2. Kumar Pradhan. Dita matter item 24. So 24 of BLFPL 3861 of 2023. So Kumar Pradhan. Single accused. What is the date of custody of that? Apanagara file.
Date of custody.
21/3/2020 and the last one is BLAPL number 4726 of 2023. Name is Kalia alias Sushant Pradhan. A be sole accused.
Yes.
What is the date of custody?
20/2/2020.
Okay, all the three petitioners, they have come earlier.
I have come earlier.
Okay, what about you, Mr.?
Yes, sir. Get the number. BLFL 9260/22.
All right, so let us come to that. Mr. Chand,
Madam.
item number 2 tower.
Madam.
Supplementary item 2. So your bail application was rejected in which? What is it?
2764 of 2021.
Have you got the copy of that order?
Sorry, my lord.
Then how can I know that it was disposed of by me and that?
No, it is by my lord. And I have also mentioned
to kete kouchandi
2764 of 2021.
अपलोड ही नहीं किया आप ऐसे ना देखी ना दी देखिले बाहर कले
2764 of 2021 BLFL.
हाँ तो ऑर्डर टा कौन है जी देखियो ना 9 नंबर टा
2764 of 2021 BLFL.
ऑर्डर टा बाहर करो 6921 share it okay उठाओ yes the summit occurrence in question took place on so at about 10 a.m. and the eyewitness Manas Ranjan Singh was accompanied with the deceased Aditya Kumar Ran Singh and Bhagwan Swai at the time of occurrence. He stated in the FIR that 4 named persons along with 4 unnamed accused committed the crime and assaulted both the deceased. FIR was lodged after death of both the deceased, but in spite of that, the name of the petitioner doesn't find place in the FIR, and even though it is a prosecution case, dying declaration was made by the deceased Bhagwan Swai while he was being shifted to the hospital, but the said aspect was conspicuously absent. Submitted that in a dying declaration, it is mentioned that one Puppu Pradhan and Balia Pradhan had assaulted the deceased by a sharp cutting weapon and therefore in use one. Up. No, Are? Just a minute. Contended that even though the FIR doesn't reflect the name of the petitioner, but in the dying declaration, the deceased Bhagwan Swai was made before so and so the name of the petitioner finds place as an assailant, the deceased, and both in so and so statements of these 2 witnesses have stated about the same. The dying declaration has also been recorded in the mobile phone of Pramod Behera, submitted the postmortem both the deceased sustained number of so and so. Upru Howdy. Informant opposed the prayer for bail. Submitted occurrence has taken place in a pre-planned manner, and while the deceased persons were coming in a motorcycle, wire was tied on the road, and when they stopped their vehicle, the accused persons assaulted the deceased. Deceased Swans was shifted to SC Medical College, made dying declaration before Swans. Also, father submitted that SC Medical College father submitted will consider Swans of the nature of, even though in the FIR, the name of the petitioner is not there, but taking into account the fact that name of the petitioner finds place in the dying declaration of the deceased and the manner in which the offense has taken place. post-mortem report at this stage, while not inclining to release it, direct the SDGM to expedite the commitment of the court and so on. Okay. So renew the prayer after examination of such witness. So that was the liberty granted.
In the meantime, I can have a glance to my the BLAP number 124 of 2023. Madam has dealt details regarding the dying class.
Reject ହେଇଥିଲା ଦେଖିଲେ କୁଆଡେ ଉପରକୁ
ଏଟା ରହୁଛି ଆଜ୍ଞା 6/9/2021 6/9/2021
6/9/21 rejected. What did he change?
In the meantime, I see I have given the copies. BLAPL number 124 of 2023. One Goni alias Goneshwar Pradhan has been granted bail, who has not named in the FIR as like the petitioner, and also not his name was not found place in the dying declaration. And subsequently also,
no, your name is there in the dying declaration. Yes,
madam. And another person, one my lord,
there are no eyewitness based on dying declaration of the deceased. Bhagwan Swami stated to have PW4 was recorded by so from the Vivo mode such recording downloaded and stored to pen drive. Copy of the same has been served on the Land Council. Same has been marked as MO2. Land Council further submitted the allegation was made in the dying deceased implicated petitioner Goni alias as one of the SLN. But after playing the pen drive, it was found that the deceased Bhagwan Swami has not uttered the name of the petitioner to be one of the SLN. And Council also informant wanted to obtain whether the name of the petitioner finds space in the dying declaration made before PW4, which was recorded and stored in some mark. Is directed to carefully view and listen to the pen drive. Today, the Land Council for the state has produced the report of the inspector in charge and so on. Wherein it is after playing the pen drive in which the entire incident was captured, it was ascertained that the name of the petitioner Goni alias Goneshwar Pradhan, son of so-and-so, Bhile so-and-so, was not stated by accused Bhagwan Swami, and it further reveals case record that the statements of witnesses so-and-so have been recorded under section so-and-so, and both of them stated the name of the petitioner as accused with others in their statement. Report is taken under them. In the recorded dying declaration, the name of the petitioner is taken into account. So, the reason has been given there.
And I pray, my lord, to have a glance to that my lord's order, BLAPL number 4605/2023, Brahmor alias Bhapanavara Pradhan. The next one. There has been no name in the dying declaration. One time, Brahmor Pradhan.
So, you have to supply the deposition copies to the State Council.
We have already supplied, my lord. In my case, also.
PW5 there are 8
8 witnesses have been examined as it seems. ମାନେ ଯୋଉ order ଆପଣ ଦେଲେ ଆଜି 13/10/2023 ର ସେତେବେଳକୁ ପୁରା PW8 ମଧ୍ୟ ଦେଇଥିଲେ ନା, ତେଣୁ 8ଟା ୱିଟନେସ୍ ଦେଇଥିଲେ, ତ ତାଙ୍କୁ 3ଟା 5ଟା କ'ଣ ଦେଇଛନ୍ତି, ଆଉ 3ଟା ଦିଅନ୍ତୁ ଆପଣ। ସେ ଭେରିଫାଏ କରିବେ with claim priority ଯୋଉ କହୁଛନ୍ତି, ଏ କପି ଦେଲେ ତାଙ୍କୁ ବେଲ୍। So let these 3 matters come next week. In the meantime, you supply the. Have you received the copy of the bail order of Goni alias Goneshwar Pradhan and Brahmor alias Brahmorvar Pradhan? Okay. Simultaneously, Mr. Chand will give you the deposition copy of the rest 3 witnesses, right? You examine whether all these three petitioners, they stand on the similar footing or not. All right.
Madam, I may excuse my lord. Week list 117, my lord. Similar case, similar footing, my lord.
Similar case mane kon? Same case
Same
ele
case, same case.
Oh, same case.
Same case. 117, my lord. Week list.
Kitne number BLAPL ko?
My lord, BLPL 10250.
10250.
My lord.
Of?
My lord, 23, my lord. And another matter, my lord, 4941, 23.
ये जो BLAPL 10250 टा कितने number item को कहती?
117, my lord.
There is single accused.
Single accused, my lord.
Dipu Pradhan. How would account कहले?
My lord, 494123, my lord.
List अच्छी.
My lord, गोला list थिला कोटी first थिला कोटी है.
कितने number?
4941, my lord.
4941 of
23, my lord.
ना कौन कौन थी?
Tera alias Susan Pradhan.
Alright, ई गोटा के order pass करूँ तो BLAPL number 941 of 2023 है ना? Mr. Manas Shah, Land Counsel, appearing for the petitioner, submitted that similarly situated co-accused persons, namely Goni alias Ganeshwar Pradhan and Brahmar alias Brahmarbar Pradhan, have been released on bail by this court by order dated 18/8/2023 and 13/10/2023 in BLAPL number 124 of 23 and BLAPL number 4605 of 23 respectively. He has handed over the deposition copy of 5 witnesses to the Learned Counsel for the state.
The rest, my lord, I have just now supplied.
He has supplied the deposition copies of 8 witnesses examined so far in the examined so far in the trial court. Let the Learned Counsel for the state verify the case diary and with reference to the bail order regarding claim of verity of the petitioner. List this matter along with BLAPL number 3861 of 2023, bracketed Kumar Pradhan versus State of Orissa, BLAPL number 4726 of 23, Kalia alias Sushant Pradhan versus State of Orissa, BLAPL 10250 of 2023, Dipu Pradhan versus State of Orissa, BLAPL 4941 of 2023, Tera alias Sushant Kono? Pradhan versus State of Orissa on 10th of November 2023.
Number 3.
May I please, your lordship? The IA which was filed, my lord, that is.
Yes, Mr. Sahu.
IA which is filed, my lord, that will not press, my lord.
IA number 1444 of 2023. This is an application for appropriate order. The Learned Counsel for the petitioner does not want to praise the interim application. Accordingly, IA disposed of. Yes.
For alleged offense, my lord, 399402.
Case diary, Mr. Tripathi.
All the co-accused granted bail. Charge sheet submitted, my lord. Custody since 26/6/23. Nothing has been seized from my possession. I have annexed, my lord, annexure 1, page 6, your lord.
Received the case diary. Let it
Charge
come
sheet
next week in the meantime.
charge sheet
And
submitted, my
say
lord.
399 402. How many cases are
My-
there against you?
2 cases, my lord. One 498A, another 307. I have filed affidavit.
Affidavit, comprehensive affidavit
Yes.
copy diyon tam.
Aye.
The learned counsel for the petitioner submitted that the petitioner has got 2 criminal antecedents and he has filed a comprehensive affidavit relating to the status of those 2 cases, serving copy on the learned counsel. Dele ta apanku?
Aye.
Copy in court today. Learned who submitted that he has not received the case diary. In view of such submission, list this matter on 10th of November 2023.
In supplementary list.
हाँ एगुड़ा सब आसी sir. Yes.
Item 4. May I please your lordship? My lord, my name is not in the affair, my lord. And other co-accused also be on release on
Why
bail.
you are seeking for interim bail?
Yes, my lord.
Why you are seeking na? Yes, my lord.
Interim bail you are
कौन पाई interim bail?
interim bail my lord बहुत दिन हैला पढ़ न थिला बोली कि
एटा को not press करी देबे तो?
Yes, my lord.
IA number 1210 of 23. This is an application for interim bail. Learned counsel for the petitioner doesn't want to press this application. Accordingly, IA is disposed of. Yes, कौन meritor कौन?
My lord.
आगुर reject ही ना इटा first time.
No, इटा first time, my lord.
First time.
My lord.
What are the offences?
Offenses, my lord, under section 419, 420, and 467, 468, 471, and 120B of the IPC.
So, since when you are in custody?
My lord, 11th April 2023.
Yes.
My lord, my name is not in the affair, my lord. Thereafter, Subhash Koradai is also be released on bail, page number 32. Mamata Koradai also be in affair. FIR name ଅଛି page number 30.
FIR ଆପଣଙ୍କର ହଉଛି annexure 1.
FIR annexure 1, my lord.
Annexure 1 is against 2 persons.
Yes, my lord. That is also be ମାନେ
Subhadra Parida
and Mamata
Parida, right?
Yes, my lord. They two persons, they are also be released on bail, my lord.
Both the FIR named accused.
Yes, my lord.
Okay.
Thereafter, my lord, other co-accused, my lord, you may. My lord, page that is annex 3 page running page 31, my lord. That is also be granted, my lord, bail. Annex 3 page number 31, my lord.
31.
That is Haladara Das. Not in name, my lord, FIR. Thereafter, my lord, page number 33. That is Antaryami Senapati. That is no FIR in name, my lord. They are also be granted and bail, my lord. You may kindly glance, my lord. Interim bail also be given, my lord. This honorable court. Thereafter, my lord,
ଆପଣଙ୍କ ନାଁରେ କଣ ଅଛି?
ମୋ ନାଁରେ ସାର୍ ମାନେ ମୋ ନାଁରେ ମୁଁ ଆଡଭୋକେଟ କ୍ଲର୍କକୁ ମୁଁ ମୋର କାଗଜପତ୍ର ଦେଇଥିଲି ମତେ ରେସନ କାର୍ଡ କରିବା ପାଇଁ, ହେଲେ ସେଟାକୁ ସେ ମିସୟୁଜ କରିକିରି ମତେ ଘରକୁ ଆଣିକିରି ମତେ ଆରେଷ୍ଟ କରିଦେଇଛନ୍ତି.
Impersonating.
Impersonating
as the seller, he sold that.
That is the
instruction.
My lord.
EOW matter. तो आपण ही ताकू से जो सत्यभामा दास को जे कि होची ओरिजिनल ओनर ताकू इम्पर्सोनेट करथिले करिकिनी फोर्स्ड आधार कार्ड इत्यादि प्रोड्यूस करिकिनी से लैंड सेल
माइलर से कहउछन्ती किंतु सर मोर एफआईआर रे माने एडवोकेट क्लर्क अंतर्जामी सेनापति मोर मोर आधार कार्ड नैथिला एवं से सब करला ट्रायल रे मु कहिथांती योर लॉर्डशिप
आपण जेतेबेले फाइनल ये हुए you are to remain present at the without your presence can it be done registration केमती हबो आपनकर सेल डीड आपण registration करथिबे ना
हां यस माय लॉर्ड
registration बेले आपनको प्रेजेंस ही नथिबो
नहीं सर मो प्रेजेंस नथिला से
आपन आधार कार्ड आप जो फोटोटा अछि आधार कार्ड आपण देखैचंती सत्यभामा दास से सत्यभामा रो ओरिजिनल सत्यभामा दास जगह आपनको फोटोटा लागिछि आपनको सिग्नेचर अछि आ नाइ कोन कहउछन
योर लॉर्डशिप माय एनेक्सर माय मु ए3 पेज नंबर 49 मोर आधार कार्ड एटा माय लॉर्ड मु देइछि माय लॉर्ड एनेक्सर
आपनको ओरिजिनल आधार कार्ड काई आपनको
मोर माने 49 माय लॉर्ड पेज नंबर 49 योर लॉर्डशिप यू मे ग्लांस माय लॉर्ड गायत्री मल्लिक जन्म तारीख 10/3/1987 माय लॉर्ड
ते फोटोटा खाली मिसुथबो आ अन्य सब डुप्लीकेट थिबो ते फोटोटा रे आपण
हां से
माने गायत्री एटा जो तार ओरिजिनल ओनर रो सत्यभामा दास येचंती बाकी सब सत्यभामा दास रो एड्रेस फैड्रेस सब लिखा हिथिबो फोटोटा किंतु केवल आपनकर अछि
माइलॉर्ड से माने मिसयूज करचंती तेनु करी माइलॉर्ड मु होची होम मेकर माइलॉर्ड मोर एंटीसेंट किछि
वेरीफाई हिथिबो ना आपण फोटोटा सेटली मैच कला से पई आपण दस्तखत नेले आपण निजे दस्तखत कर देले सत्यभामा दास हिसाब रे सब कला पर केते टंका पुनी से टंका आडा कोड गला से लोकटार जमी जो ता जमीटा को नै बिकी देले से लोक
para 7 units. Para 7 of the instance. TI period was done and we identified.
TI period was conducted and the victims so and so identified. पैसा केते आपनकर ता जरु ये कर जंदी प्राइस केते सेल डीड बाया को केते टंका मिलची ए टंका आपण नै थिबे
नो माय लॉर्ड
नै नथिबा के नै थिबो आपण सेल डीड कले पैसा आपण को दियाला जमी होची अन्यर से लोक पाइलानी आ पैसाटा आपण देबेनी
माय लॉर्ड व्हाट हैपेंड माने समस्ते मिसी की सर ये होची होम मेकर योर लॉर्डशिप यू मे काइंडली सी माने मोर पिला मानकर मध्ये मो आधार कार्ड देछि योर लॉर्डशिप मो पेज एनेक्सर 7 माय लॉर्ड
what is the amount consideration of money in that sale deed
32 lakhs above
32 lakhs नै जंदी so how much you will deposit tell me
माय लॉर्ड सर अन्य माने समस्ते पळे जायछन योर लॉर्डशिप
पळे जायछन जे आपण
माने माय लॉर्ड मु सिंस मु माने झियो पिला
their role is that somebody has identified you as Satyabhama right but you impersonated as Satyabhama they are equally liable but you are the very person who was present whose photograph were used and forged Aadhaar card was produced and you have been identified that this lady come and impersonated as Satyabhama Das so all these things are there a tonka se lokotar bartaman taku entire thing he has to nullify that sale deed for that he has to entire proceeding has to be instituted and is to come to the court and all the evidence he has to adduce and he will enjoy with the money
no your lordship माने fairly I submitted. My lord, मु homemaker, my lord, your lordship. माने विश्वास करନ୍ତୁ ମୋର ପିଲାମାନଙ୍କର ସାର୍ଟିଫିକେଟ annex 9 year may
how much amount you can deposit, you take instruction. It's a economic offense. Somebody's land has been sold without his knowledge, and you are the lady who impersonated the original owner, and the constitution money is there. So make deposit of some amount.
My lord, other ଆଜ୍ଞା ମୁଁ ଜଣେ ହିଁ
instructions regarding the amount.
What is that?
Misappropriation amount
Consideration say amount
32 lakhs ଅଛି but various type ଆହୁରି ବି ପଇସା ଦେଇଛନ୍ତି।
ଆଜ୍ଞା ମୁଁ ଆଜ୍ଞା ମୁଁ ସେଥିରେ ଗୋଟେ ନୂଆ ପଇସା ମୁଁ ଯୋଉ ନେଇ ନାହିଁ ତାପରେ
ସେମିତି କହିଲେ ହବନି ରେକର୍ଡ ଯାହା ଦେଖଉଛି ଆପଣ ନେଇନା ଆପଣ କହିବେ ମୁଁ ଯାଇ ନଥିଲି ମୁଁ ତାଙ୍କୁ କାର୍ଡ ଟା ଦେଇଦେଲି ଆଉ କାର୍ଡ ଟା ଦେଇଛନ୍ତି ଆପଣ ଅଫିସ କୁ ଆସିନାହାନ୍ତି ସେ କେମିତି ସେମାନେ ଆପଣଙ୍କୁ ଆଇଡେଣ୍ଟିଫାଇ କଲେ
all are bail granted sir ମୁଁ ଜଣେ ହିଁ ରହି ଯାଇଛି
you are the main person ରହିଲେ
no you are also interim bail
ଆପଣ ଯଦି ଛିଡା ହେଇନଥାନ୍ତେ ଜମି ହେଇ ପାରିଥାନ୍ତା କି ଆପଣ ଯୋଉ ଛିଡା ହେଲେ ନିଜକୁ କହିକିନି ସେ ଯୋଉ କଣ ସୁଲୋଚନା ନା କଣ ସତ୍ୟଭାମା ଦାସ ହିସାବରେ ନିଜକୁ ପ୍ରୋଜେକ୍ଟ କଲେ ଆଧାର କାର୍ଡ ରେ ସବୁ ଫର୍ଜରୀ ଆଧାର କାର୍ଡ କଲେ ଏସବୁ ଯଦି ନ ହେଇଥାନ୍ତା ଜମି କଣ ବିକ୍ରି ହେଇ ପାରିଥାନ୍ତା ସେଲ୍ ଡିଡ୍ ଏକ୍ଜିକ୍ୟୁଟ ହେଇ ପାରିଥାନ୍ତା କି ତେଣୁ ଯୋଉ ଟଙ୍କାଟା ଆପଣ ଏକ୍ସ ର ଜମି ତାର ଅଜାଣତରେ ବିକିକି ନେଲେ ସେ ଟଙ୍କାଟା ଦିଅନ୍ତୁ ଆଣିକିନି
sir your lordship interim bail may be given my lord my lord
all right let him take instruction and you also take instruction how much amount you can deposit the learned counsel for the petitioner submitted that the petitioner is in judicial custody since 11/4/2023 and she has not been named in the FIR and the FIR named accused persons as well as some other co-accused persons have been released on bail.
All my lord. ସମସ୍ତେ ପଳେଇ ଯାଇଛନ୍ତି except ମୁଁ ଜଣେ ହିଁ ରହିଛି.
The learned counsel for the state on the other hand produced the written instruction received from Deputy Superintendent of Police EOW CID CB Bhubaneswar from which it appears that the petitioner impersonated herself as Satyabhama Das using forged Aadhaar card and sold away land of the original owner to different persons, namely Pradipta Behera, Monalisa Behera, Sulochana Pradhan, and Damayanti Das. And the purchasers in the test identification parade have also identified the petitioner to have impersonated Satyabhama Das. The learned counsel for the state submitted that the consideration amount in as per the sale deed is rupees 36 lakhs na 32 lakh. Let the learned counsel for the petitioner obtain instruction about the deposit of the amount in the court below. Put up this matter next week rakhibi
I will also verify man
put up this 10/11/2023 the learned counsel for the state shall also obtain regarding the criminal antecedent if any against the petitioner. Au kete case re emti impersonate karchi anantu yeah
supplementary list ଆସିବ
supplementary ଆସିବ 10 ତାରିଖ ଦିନ yes
Weekly list item number 1.
May I please your lordship? May I please your lordship?
Yes.
Lordship, offense is under section 21B of the NDPS Act. Here the CICL is forwarded before the learned board on 10/7/2023. Here in this case, as per the story of the prosecution is that, my lord, the police raiding team got an information that two persons were selling adulterated cough syrup. When they reached to the spot, they found 340 numbers of cough syrup, 350 numbers of Valdrax cough syrup from the position of the present CICL. And one accused, the principal accused, is already fled away from the place of occurrence. Basing on that, the appellant approached before the learned court below, where the learned court below pleased to reject the same high criminal appeal
Yes,
number.
Mr. Tripathi.
Yes, my lord. Yes, my lord.
Have you received the case diary?
No, the first time it has come.
Oh, first time it has come. So the offense is under 20 bracket B lekha aichi of the NDPS Act, but it appears that 350 numbers of cough syrup was seized from the possession, and
more than 3 kg.
The quantity is 100 ml in each.
Yes, ma'am.
So, and it was having codeine phosphate. So now the decision is of the Honorable Supreme Court is that not only the quantity of that codeine phosphate, but the entire liquid is to be taken into account.
Yes.
For the purpose
3
of,
kg.
so if it is, then it becomes about 3.5 liters now.
Yes.
So I think it is the commercial quantity.
Yes, yes, yes.
How did you register the case under 20B of the NDPS Act?
At that time, Miller.
No, your investigating officer is not aware about the decision of the Honorable Supreme Court.
Maybe.
So you receive the get the case diary and particularly ask the IO about this aspect.
Yes, Miller.
Give him that citation to read, and so Land and Council, once it becomes the commercial quantity, you are to satisfy the bar under section 37 of the NDPS Act, then can only you get the bail. So Land and Council for the state submitted that is yet to receive the case diary, and the matter may be taken up next week. The Land Council for the state submitted that even though the case has been registered under section 20B of the NDPS Act 1985, but from the rejection order, it appears that 350 numbers of sealed cough syrup bottles, each containing 100 ml, having codeine phosphate and trifluidine hydrochloride syrup, were seized, and in view of the quantity of the cough syrup with the liquid and the decision of the Honorable Supreme Court, the quantity comes, it comes within the commercial quantity, and he has to ascertain, he has to take instruction on that aspect also, along with the availability of any criminal antecedent, if any, against the appellant or petitioner. Put up this matter, and you also produce that what is
social
that?
investigation.
Yes. Social investigation report.
Yes.
List this matter next week.
3 copy, Miller.
3 copy of the order.
Item number 2.
Yes.
Lordship, I pray for next week, Lordship.
Okay.
Next week,
In the meantime, if Lordship permits, the impugned order indicates there are 7 forest officials.
7
accused persons who are all forest officers involved of misappropriation case pertaining to plantation lots. And by this particular orders at page 130, the case has been posted for framing of charge on 17 August. If in the meantime charge has been framed,
what is your instruction?
I will obtain the up-to-date function.
What is the rejection order? That
130 minutes, 130. the discharge application having been rejected, they prefer this
just a
revision.
minute. Okay. The petitioner has challenged the order dated 4/8/2023 passed by the Learned and Special Judge Vigilance Bhavani Patna in GR bracket V number 21 of 2021 in rejecting his petition under section 239 of CRPC for discharge. The impugned order reveals that the case was posted to 17/8/2023 for framing of charge. When a query is made to the Learned Counsel for the petitioner as to whether charge has been framed or not, he seeks some time to obtain instruction and to produce the certified copy of the order sheet from 17/8/2023 onwards. Hejivo Tasanda Saptarani Parive. As prayed for this matter on 10th November 2023.
If Lordship permits, Lord, may I indicate one of the notes. Out of the 7 accused persons were added as opposite as the accused lords. The FIR is dated 15/12/2021, page 12 lords. Whether any other, the number of other revisions filed by other 6 accused persons. So can be tagged off. If you also turn to page 12 lords, that FIR dated 15/12. Page 12 indicates FIR dated.
No, you are right, but some CRLMC application is pending before this court. Just a minute.
Because all revisions, if article filed millers are directed against one input orders.
No,
can be tagged off, can be disposed.
This order is dated.
Yes, I'll also turn to page 12, dated 15/12/2021.
What is the impugned order dated?
Impugned order dated 4/8.
4/8/23.
या year किछि देखोनी माने किछि pending थिला बळ्या.
Out of the FIR dated, I think.
No, if anybody has filed, you must have received the copy of the.
That also, that part I will verify. I believe 1-2 revision has been filed.
So give the number if you get it on the next week by next.
Yes, Lordship may not pass any orders, then I will find out. If any revision petition has been served on us, I will supply the number. Next step notes.
This petition, which was rejected, 239 CRPC, that was filed by all the petitioner, all the accused persons, or one accused?
Only one accused person.
So how can they file? The order. Have you got the copy of the 239 CRPC petition?
Yes,
so where is that? Have you filed it?
That
yes. Annexure 4. Annexure 4.
115, your lordship.
Annexure 4, Mr. Das. Please see Annexure 4. It is only filed by Antarjami Das, who is the petitioner.
115.
115, 115.
Annexure 4.
So that is filed by only one person. However, you verify if anybody has filed any petition and put up this matter.
I believe this Susanta Kumar, that Susanta Kumar Samantra has filed. I believe not, sir. Verify.
But in this impugned order is relates to only this petition.
That he has indicated.
Yes. So it will come on next week and you file that order sheet.
Date is not 11.
10th.
10th of November.
Yes, next
case. Come in the supplementary.
Infectious and disposed of. Yes.
Item 4.
Wait, please, Your Lordship. My Lord, this is third time bail application before this honorable court, my Lord.
Yes.
Initially, my Lord, Honorable Dr. Justice S.K. Panigrahi, sir, disposed of petitioner's bail application twice, my Lord, by BLPL number 5417 of 2020, and another is BLPL number 4780 of 2021, my Lord. Lordship may kindly pay.
What is the date of custody?
My Lord, since 7th July 2020, my Lord.
7 July
2020.
What are the offences under which charge sheet submitted?
302 only, my Lord. Sorry, my Lord. 302, 201, 120B, and 34 of IPC.
Name of the deceased?
Gurju Rana.
Yes.
Gurju Rana.
Garju. Garju.
Okay. FIR against unknown person.
Unknown person, Your Lordship. The FIR registered under 302 against unknown person.
So, is there any eyewitness to the occurrence?
According to the prosecution case, my Lord, one eyewitness to the occurrence is there, my Lord.
What is the name of that?
PW number 8, Your Lordship. PW number 8, Nepal Rana. The prosecution declared hostile, Your Lordship. My Lord.
Deposition copy you have given?
Yes, Your Lordship.
PW8.
8. I know the informant. I also know the deceased Gurju, but I do not know the accused person who was standing inside.
So he has not supported the prosecution.
Yes,
case.
my Lord.
Yes,
my Lord.
What about other witnesses?
All the material witnesses are examined, Your Lordship.
What they have stated against you?
2 person, Your Lordship. The daughter. They are not eyewitness.
No, who have stated against you? କିଏ କହିନାହାନ୍ତି ଆପଣଙ୍କ ନାଁରେ କିଏ କହିଛନ୍ତି କି ଆଜି ପର୍ଯ୍ୟନ୍ତ ଯୋଉମାନେ ଏକ୍ସାମିନ ହେଲେଣି ଟ୍ରାଏଲ କୋର୍ଟରେ?
My Lord, 2 person, Your Lordship.
କିଏ?
One is Sunita Rana.
PW କେତେ?
PW1.
Okay.
And PW2.
And in what way they have implicated you? What is the deposition copy?
The PW1 and PW2, my Lord. May kindly produce.
Have you have not given the deposition copy of 1 and 2?
Already given, my Lord. Initially, the 1 to 6 depositions copy given. Thereafter, 7 to 16.
देख रहे हो deposition copy जरा. (6 to 16) that is filed with a memo.
My Lord.
But
prior
you say that
prior to that, my Lord, the previous councils submitted 1 to 5, my Lord.
1 to 5. June. 1 and 2 darkar. Yes.
May I read your
what they have stated against you?
My Lord, they stated the accused made a phone call on my mobile phone that whether knots are available or not. I replied that knots not available in my house and my father had gone to Titlagarh. Thereafter, my Lord, in the second paragraph, the accused has committed this type of activities 2 to 3 times before and has sent his friends to our house to kill my father, as my father conducted marriage of my sister elsewhere. Because, my Lord, the petitioner and the deceased daughter, they both have been in a relationship, Your Lordship. And the deceased conducted the marriage of the daughter in any other place. For that reason, the accused and other person murdered the deceased. That is the allegation, Your Lordship.
So, when your bail application was last rejected?
My Lord, last rejected on 29th November 2021.
That in BLAPL number?
4780 of 2021. In that bail application, Honorable Court observed, my Lord, considering the statement of that eyewitness, sole eyewitness, namely Nepal Rana, he is not examined that time. For that reason, this Honorable Court disposed that bail application.
So, say order, say file touch BLAPL 4780. Yes, Mr. Tripathi, what do you say?
Yes, sir. That PW1 Miller, the Sunita Rana, at Para 2, may I read it, Miller?
Yes.
About 1 year back, accused Adil Mohammed made a phone call on my mobile phone that whether notes available or not. I replied the notes not available in my house and my father had gone to Titlagarh. On 10/5/20, the marriage of my elder sister was fixed. On the previous day, at about 8 p.m. at night, the accused Adil Mohammed came to our house and called my elder sister Rinki Rana to go out with him. My sister denied his request. The accused target to kill my father. The accused Adil Mohammed has committed this type of activity 2 or 3 times before and had sent his friend in our house to kill my father. As my father conducted marriage of my sister elsewhere. My sister got married on 10/5/20. Subsequently, on 2/7/20, the accused person Mukesh Barik, Adil Mohammed, Rajaram Chorua, etc. had killed my father near the village mountain by cutting his neck.
No. The occurrence in question, according to the prosecution, took place on 2/7/2020.
Yes.
And this occurrence of threatening, etc., that was made on 10/5/2020.
Yes.
But in spite of that, when the FIR was lodged,
yes,
the name of the petitioner doesn't find place in that FIR.
Yes,
now the bail application was rejected mainly that there is an eyewitness to the occurrence. The eyewitness has been examined as PW8 who has not supported the prosecution.
No.
Are the learned counsel for the petitioner, learned counsel for the state? The learned counsel for the petitioner submitted that the petitioner is in judicial custody since 7/7/2020 and he has been charge sheeted under section 302, 201, 120B34 of the Indian Penal Code. The occurrence in question took place on 2/7/2020 and the first information report was lodged on the very day against unknown persons by one Rohit Rana,
nephew of the deceased.
Nephew of the deceased, Garju Rana. It is argued that the last bail application of the petitioner in BLAPL number 4780 of 2021 was rejected as per order dated 29/11/2021. However, in the meantime, the eyewitness to the occurrence, namely Nepal Rana, has been examined as PW8 in the trial court and he has not supported the prosecution case. It is argued that by now 16 witnesses, 16 na?
16 witnesses has already
16
examined.
witnesses have already been examined in the trial court and no clinching evidence has come against the petitioner. And in view of the period of detention of the petitioner in judicial custody, the bail application may be favorably reconsidered. Learned counsel for the state opposed the prayer for bail and placed the evidence of one Sunita Rana, who has been examined as PW1 in the trial court. Considering the submission made by the learned counsel for the respective parties, nature of evidence adduced so far in the trial court, period of detention of the petitioner in judicial custody, I am inclined to reconsider the prayer for bail and direct the petitioner to be released on bail, will appear before the London trial court on each date when the case posted for trial, will not indulge in any criminal activities, violation of any terms and conditions shall entail cancellation of bail allowed.
Grateful, my lord.
Yes.
Item number 5.
5, Mr. Gopal Krishna Mahanti. Not there. Next case.
Item number 6.
Yes, Mr.
Barrister.
Yes.
My lord had already changed the terms of the deposit and reduced it to 20,000 rupees. Not able to pay, my lord, in the meantime.
No, just a minute. What order you said? You will deposit a sum of rupees 20,000.
Yes, my lord. After
per month till clearance of the balance amount.
17 lakhs, 9 lakhs is paid in the meantime. Not able to pay anymore, my lord. He was a sarpanch, my lord.
Just a minute. ଆପଣଙ୍କର ବେଲ୍ ଅର୍ଡରଟା ମଡିଫାଏ ହେଇଯାଇଥିଲା ପରା ଥରେ?
ହଁ,
23/12
the bail order was dated 22/7/2022, right?
Yes.
And
my lord, we're pleased to change it on.
There was a direction to furnish cash surety of rupees 4 lakh and balance amount kete thila?
My lord, total amount was 17 lakhs. I have in the meantime paid 9 lakhs.
17 lakhs through 9 lakhs diyaji.
Yes. Not able to pay, my lord, not able to meet the commitment.
ये जो 9 lakhs payment କରିଛନ୍ତି ବୋଲି documentary proof ପାଇଁ.
Yes. And we have filed it, my lord. Copy has been filed, my lord. Total, all the orders put together, my lord, I have given the copy of the order sheet. Comes to 9 lakhs, my lord. An affidavit of, also has been filed, I think, in your
କୋଉଠି ଦଉନାହାନ୍ତି ମୁଁ ସେଇଥିପାଇଁ କହୁଛି ଆପଣ ମତେ ଗୋଟେ documentary proof ଦିଅନ୍ତୁ ଯେ ଆପଣ 9 ଲକ୍ଷ ଟଙ୍କା deposit କରିସାରିଲେଣି ବୋଲି.
This is the memo. This is the memo, my lord. Copy of the order, my lord. Over a period of time. First, my lord. देखें आता copy. 5 lakhs was deposited on 23/7/2021.
The amount you have stated in paragraph number 4.
Yes, my lord.
Of this IA.
Yes.
That out of the alleged amount of rupees 17,31,500.
Yes, 9.
Yes, you have paid a sum of rupees 9 lakh. What do you say, Mr. Tripathi?
That is modified on 23/12, my lord.
Yes, yes.
हाँ ते गोटे थोड़ा modify ହେଇଯାଇଛି.
Yes.
But
again and again he is coming, my lord.
पैसा ଦେଇ ପାରୁନାହାନ୍ତି ନହେଲେ ଭିତରୁ ପୁଣି ନେଇ ପୁରେଇ ଦେବେ. Otherwise, Mr. Das would have spent it from his own pocket.
I also come, my lord, in those circumstances.
All right. IA number so and so. This is an application for modification of the order dated so and so. After considering the submission made by Mr. Das and senior advocate that the petitioner has already deposited rupees 9 lakhs out of the alleged misappropriation amount of rupees 17,31,500 and is unable to furnish the cash surety of rupees 8,31,500. The order dated 23/12 first order and so last order is modified to the extent that for the balance amount the petitioner shall furnish property surety before the trial court.
Deep level.
I will disposed of.
Matter is there tomorrow, my lord, before the trial court. We can have.
So, no, you just, it will be
make an
uploaded today, and if not there, then you file the affidavit that
Yes,
this order
we'll
has
file
been
an
passed. Yes.
Item number 7.
In 7, my lord, this is a transport brief, and just now I am filing the fresh Wakalatnama on behalf of the petitioner, my lord. Lord, so far this petitioner is concerned, my lord. Once it was rejected, my lord, due to antecedent, my lord.
Now, ଆପଣଙ୍କର last bill application number କେତେ?
2632. That is
2632. କାହିଁ ସେଟା ବାହାର ଅଛି?
52.
ଅଛି ଆଗ rejection order ଟା?
No, my lord, that is tagged with
2632 of
21.
21. Wait. 2632 କଣ କହୁଛନ୍ତି ସେଟା 52 ଟା ହଉଛି ଗୋଟେ ରଞ୍ଜନ କୁମାର ବୋଲି ଜଣେ ତା ନାଁ ଏଇଟା ତ
ଆଉ ଗୋଟେ ଅଛି 2463
ସୁଧୀର କୁମାର ରାୟ ଯାହା ଇଣ୍ଡିକେଟ କରୁଛି ଆପଣ this is your second bail application.
Yes,
so the first one is 2661 of 2021. ସେଟା ଭୁଲ କହୁଛନ୍ତି ନମ୍ବରଟା
transport brief, my lord.
2661 of 2021. So now you are in custody since when?
Lord, 8/7/2021, my lord.
It's a commercial quantity.
Yes, my lord.
You
64 kg.
You are a man from Bihar.
Yes, my lord.
So what about the address verification and what is the status of the case?
That has not obtained. Status, my lord, charge yet not framed, my lord.
All right, the Land and Council, let the status report come. The Land and Council for the petitioner submitted that earlier the petitioner approached this court for bail in BLAPL number 2661 of 2021. এটা বাহার করলে সে অর্ডারটা BLAPL 2661 2021. Last 33 which was disposed of as withdrawn on 33/2022. Land Council submits custody data लिखेगी 8/7/21. Petitioner is in judicial custody since 8/7/2021 and he has instruction that no charge has been framed. Let a status report be called for from the London Trial Court, that is Session Judge cum Special Judge Gajpati Parla Khemundi in GR case number 34 of 2021. Baki usual order kar debi. Since the petitioner is from state of Bihar, Land Council for the state shall obtain instruction regarding the address verification, and in that respect usual order pass kar. Eta kato samnaru kato. Yes, next case.
Lord, my name may be reflected. File the
wakalatnama. Mr. Mononjan Padi, Land Council, files wakalatnama with no objection from the earlier engaged counsel. The name of the Land Council be reflected in the cause list in place of the earlier engaged counsels. Yes.
Public.
Item number 8.
Item 8, Lordship, refer and adjournment.
Land Council for the petitioner seeks for an adjournment. Adjourn. Yes.
Item number 9.
May I please? Offense under section 20B2C and 29 NDPS Act, my lord. I'm in custody, my lord. 26/9/20, my lord, 2020.
Agur astile?
No, my lord. That is the earlier bail application, my lord, 3137 of 2021, which was disposed of on dated 11/5/2022, my lord. As per the Pradhanjani case.
No, apono agur astile ki?
Yes, my lord.
Se pacharji mo to kon hela apon jo first time jo astile reject hela kebe seta ko bail application number kete
3137.
Order copy gay.
Order copy. That is, I have mentioned 3137/2021.
Just a minute. Let us see that. Would like mention kar jandi.
First item.
3137 of 21. Acha, that was disposed of on 11/5/2020. Acha. Now, what is the stage of the trial?
Trial commence, my lord, no witness examined. As per instruction, my lord.
Trial commence, no witness examined. Khali charge frame hi china kon.
Charge frame hai summon jais kintu witness exam.
Trial commences with the framing of the charge, right?
Sorry.
So your case is that charge has been framed, but no witness has been examined. ଆପଣଙ୍କର 3 ବର୍ଷ ହେଇଗଲାଣି. You are a local man.
Yes, my lord.
So have you got any order sheet of the trial court to show that till date no witness has been examined?
No.
Then status report will come. Dekhon. Land Council for the petitioner submitted that the petitioner is in judicial custody since 26/9/2020. And he has instruction that even though charge has been framed, but no witness has been examined in the trial court. In view of the submission, let a report be called for. Usual order. Register judicial.
And this petitioner, Miller, has 13 criminal antecedents.
That is rejection. Pardon, my lord.
And one of them is 302.
Remanded in this case, my lord, 17/2/21, my lord.
Acha, 26/9/2020 not likhi nahi. Was taken on remand in this case on 17/9/2020.
17/2.
17/2 to?
Again.
21 to?
Yes, ma'am.
Land Council for the state submitted that he has received instruction that the petitioner has got as
13.
many as 13 criminal antecedent, including
And some of them are 302.
and including the offenses under section 302 IPC.
That is rejection order.
The Land Council for the petitioner shall obtain instruction about the status of those cases and file a comprehensive affidavit to that effect, giving sub copy to the Land and Council for the state. List this matter. Gote saptah chhad dei pakega.
1 week after asal ke tangu
हाँ,
daki bi apd
ठीक है 1 week after. Yes, next.
obliged.
Item number 10.
Please, my Lordship, your Lordship granted bail to the two petitioners in this IA. They were granted bail on 19/5/2023 with a direction that they were to furnish 25% of the alleged cheated amount at the time of release on bail and to undertake and deposit the balance in 6 equal monthly installments.
Who order bail itla?
It all order dated 19/5/23.
Just a minute. Including the petitioner number 1, Pradeep Kumar Sahu, shall deposit 25% of the cheating amount. Cheating amount hala
38,3240.
Okay, and petitioner number 2 shall deposit 25% of the cheating amount, so and so, before the trial court at the time of release on bail, and both the petitioners shall give undertaking to the court to deposit the balance amount in 6 equal monthly installment, and the first installment which shall come in a month after. Yes, kaun hai ladar?
My lords, we are not in a position to deposit the cash security because of
माने initial भी deposit करना है?
And your lordship may see today an affidavit has been filed by the IO. The IO also says at paragraph 4 that it revealed from the report furnished by the senior branch manager, Bank of Baroda, Bhawanipatna branch, that the bank has initiated recovery proceeding against the property of petitioner Pradeep Sahu. That is plot number such and such at such and such PS Bhawanipatna.
paragraph ta poduchendi?
Para 4 Ajira affidavit. Which is under equitable mortgage with the bank as the petitioner failed to repay cash credit loan amount of 45 lakhs. Then at para 5, he says that the report of the DSR Bhawanipatna by letter dated 21/8/23 shows that the petitioners Pradeep and his wife Sagarika own as many as 5 landed properties at Bhawanipatna. So my submission, my lords, is that if your lordship will permit us to deposit those landed properties as security, the other 4, one of them is hooked with the bank, my lords. So that cannot be deposited. Those landed properties we can furnish as securities. Because now it's already 5 months we are not been able to go out on bail. The affidavit also doesn't disclose of the IO that we have cash or deposits which we can bring and furnish.
से जो मिस्टर त्रिपाठी
yes मिलर
जो चारटा जो बाकी प्रॉपर्टी रहउची जो रजिस्टर्ड सेल डीड रहउची तांकर ता पई किछि असुविधा नाही तो गोटे तो आपनकर मॉर्गेज पई रहिची से बैंक सेटा छाड़ दियो सो बाकी जो चारिटा आपन लिखि छनी पैराग्राफ नंबर 5 रे
yes
जे आउट ऑफ as many as 5 landed properties ता धियरु if one is excluded, then what Mr. Panda says that 4 are still there. And if the deposit
para
goes...
6, kindly have a glass para 6. That it is revealed from the aforesaid 4 number of RSD that besides the property against which recovery proceeding is initiated, the present petitioner also own landed property at Bhawanipatna acquired through the aforesaid arrest.
I don't dispute that.
So, no, what he says that suppose he will comply the other part of the order, but so far as this casualty is creating a problem for this coming out of the even though the bail order was passed in
2000.
May 2023. So more than 5 months have passed. So let it be property surety of that amount which has been mentioned, and they will also deposit this registered sale deeds before
Yes.
the trial court.
And we have also sought instruction from that Bank of Baroda whether he has any cash there. We had still not received that.
Cash thile to ଦେଇକିନି ପଳେଇ
ଦେଇଛନ୍ତି
ଆସନ୍ତି
ପରା annexure 1 ରେ ଦେଇଛନ୍ତି copy of letter dated 11/8/23 of senior branch manager Bank of Baroda is enclosed as annexure 1.
ମାଗିଛୁ ଦେଇନାହାନ୍ତି. We have sought for that instruction.
I don't understand. My reading of the English language is that it reveals from the report furnished by the senior branch manager, Bank of Baroda, Bhavani Patna. Paragraph 4 that it reveals from the report furnished by senior branch manager, Bank of Baroda, Bhavani Patna branch, wide letter dated 11/8/23, that the bank has initiated recovery proceedings against the property of the petitioner, that is plot number such and such, which is under equitable mortgage with the bank as petitioner failed to repay cash credit loan amount of 48.
ଏଇ ଯୋଉ ପ୍ଲଟ ଟା ଅଛି ଏଇଟାକୁ ଛାଡି ଦେଇକିନି ବାକି ଯୋଉ ତାଙ୍କର landed properties
ଚାରିଟା ଅଛି. Yes.
ଚାରିଟା ଅଛି ସେଇ ଇଏଟାକୁ ସେମାନେ ଡିପୋଜିଟ କରିବେ ଏବଂ they will comply the other terms and conditions.
Yes.
Are the IN number. This is 862 of 2023. Is an application for modification of the order dated 19/5/2023. With a prayer for a direction to the petitioner to furnish property surety in place of cash surety. The Land Council submitted that even though the bail order was passed on 19/5/2023, but on account of financial difficulty, the petitioner could not furnish the cash surety and therefore till date they are in judicial custody. And since as per the affidavit filed by the Additional Superintendent of Police Economic Offence Wing, CIDCB Bhubaneswar, dated 29/8/2023, there are other properties of the petitioner and 4 registered sale deeds are also available to indicate that there are other properties of the petitioner.
4 unencumbered properties.
Apart from the plot number 266, khata number 171/2566, area number so and so, eta joda paragraph re 4, which is under equitable mortgage with the Bank of Baroda, for which recovery proceeding has been initiated, the petitioner, apart from furnishing the property surety, will deposit those 4 registered sale deed before the Land Trial Court, and therefore the cash surety, imposition of cash surety be waived. The Land Council for the state opposed to the prayer submission made by the Land Council for the petitioner. Considering the submission made by the Land Council for the respective parties, the fact that in spite of the bail order dated 19/5/2023, the petitioners are not in a position to deposit the cash surety amount, the order is modified to the extent that instead of cash surety, they will furnish the property surety, and that apart, they will deposit the registered sale deed, 4 numbers of registered sale deeds. That is RSD number 8 ଲେଖା ହେଇଛି ଯୋଉ ଚାରଟା କୋଉ number ଗୁଡାକ
ଏଇଟା ସେ ଦେଇଛନ୍ତି annexure 2 କରିକିରି along with copies କିନ୍ତୁ affidavit ରେ ଆଉ ତାର details ଦେଇନାହାନ୍ତି
ସେ ଚାରିଟା ସେଲ୍ ଡିଡ୍ ଟା ଏଠି କଣ ଗୁଡାଏ ଲେଖି ଦେଇଛନ୍ତି
total ସେମାନେ ଦେଇଛନ୍ତି they have given all the sale deeds ତା ଭିତରୁ
ତାକୁ ଲେଖିବାକୁ ପଡିବ ନା ଆପଣ ସେଇ ତାରି ଇଏଟା ଆପଣ ଦେବେ ତେଣୁ ମିଷ୍ଟର ତ୍ରିପାଠୀ ଯୋଉ ଚାରଟା ସେଲ୍ ଡିଡ୍ କହୁଛନ୍ତି ରେଜିଷ୍ଟର୍ଡ ସେଲ୍ ଡିଡ୍ ସେଟା କୋଉଟା ଆପଣ ଏଠି ନେକ୍ସଟ ପେଜ ରେ ଆପଣ ଗୁଡାଏ ସେଲ୍ ଡିଡ୍ ମେନସନ କରିଛନ୍ତି 1 2 3 4 5 6 7 8 ସେଲ୍ ଡିଡ୍ ମେନସନ କରିଛନ୍ତି
ଆହୁରି ଅଛି ତାଙ୍କର କିନ୍ତୁ ଏତିକି ବାହାରିଲା ଆମ ପାଖରେ
ଓହୋ ନାଇଁ ପ୍ରଥମଟା ହଉଛି ନୁହଁ ପ୍ରଥମ ସେଲ୍ ଡିଡ୍ ଟା if your lordship will see ପେଜିଂ ବି କରିନାହାନ୍ତି ଏଟା 21/2/14 ରେ ଯୋଉଟା ଏକ୍ଜିକ୍ୟୁଟ ହେଇଛି ସେଟା ହଉଛି ପ୍ଲଟ ନମ୍ବର 337 ଆଉ ପ୍ଲଟ ନମ୍ବର 339/1 ତାପରେ next cell deed houchi relates to स्थितिवान खाता नंबर एते एकर केते प्लॉट नंबर तो नहीं next cell deed relates to
ଉପରେ ସେଲ୍ ଡିଡ୍ ନମ୍ବର ଗୁଡାକ ପଡିଛି ସବୁ ଗୁଡାକର ତ ଏଇ ଯୋଉଟା ସେ ଦେଇଛନ୍ତି
ଗୋଟେ କାମ କରିବି I will make a chart and give it me lots
ହଁ ସେ ଯୋଉ ଚାରଟା ସେଲ୍ ଡିଡ୍ ଯୋଉଡାକ ୟା ଦେହରେ ଯଦି ପାର୍ଟ ଥିବ ତାହେଲେ ଦେଇ ଦିଅନ୍ତୁ ସେ ଚାରଟା ସେଲ୍ ଡିଡ୍
ମୋର ଆଉ ଗୋଟେ ପ୍ରେୟାର
ଇଏ
the total amount of cheated amount comes to 80,99,570 so my submission will be that if those 4 properties let them be valued ଆଉ ସେଇ ଭ୍ୟାଲ୍ୟୁ ର ଯୋଉ ପ୍ରପର୍ଟି ଗୁଡାକ ମୁଁ ଦେଇଦେବି
କୋଉଗୁଡାକର
ଏ ଚାରଟା ପ୍ରପର୍ଟି if it comes to more than 80,99,570 my lord so I should all the 4 properties be given
ଏଠି କେତେ ଆମାଉଣ୍ଟ ହେଇଥିଲା କି
amount ହେଇଛି total amount of cheating comes to 80,99,570
ହବନି ଏତେ ବି ହେବନି କୋଉଟା 2 ଲକ୍ଷ କୋଉଟା 1.5 ଲକ୍ଷ ଏମିତିଆ ପ୍ରପର୍ଟିର ଭ୍ୟାଲ୍ୟୁ
କୋଉଠି ଲେଖା ହେଇଛି
ଏ ଯୋଉ ଭ୍ୟାଲ୍ୟୁ ଲେଖା ହେଇଛି ପ୍ରପର୍ଟି
ଦେଖି
ବିକ୍ରୟ କବଲାରେ ଲେଖା ହେଇଛି
ଏଟା 1,03,500 ଏମିତି ଲେଖା ହେଇଛି
ହଁ ତାପରେ ଅନ୍ୟଟା 2,10,10,000 ନା କେତେ
କେବେକାର ଏଗୁଡାକ 2014
16 ବଢି ବଢି କେତେ ହବ ଗୋଟେ 2,10,000
ଏଇ ଯୋଉ ଯେତିକ ସେଲ୍ ଡିଡ୍ କିନ୍ତୁ ହଉଛି ତାଙ୍କ ନାଁରେ
ହଁ ହଁ
ଇଏ ମିଷ୍ଟର ପଣ୍ଡା ଇଏ ହବନି ସାଟିସ୍ଫାଏ ହବନି ଆପଣଙ୍କର ଯୋଉ 80 ଲକ୍ଷ ହେଲାଣି ନା ଇଏ ଯୋଉ ଆମାଉଣ୍ଟ ମୁଁ 4-5ଟା ଦେଖି ସାରିଲିଣି ସବୁ ଗୁଡାକ ଲକ୍ଷେ
2 ଲକ୍ଷ ଭିତରେ
ଏଇ ଟାଇପ ର ଭିତରେ ହବ ଏତିକି like 8 cell deed कर दियंतु से जो आज आप पा रहे 8टा cell deed furnish कर चेंज भी लिख दियंतु registration number so and so है ना you will deposit the cell deeds and give an undertaking before the court that you will not sell any of those properties
they will not
sell any of the properties है ना
urgent
copy
Item number 11.
My lord, 11 matter become infructuous.
Mr. Roy, learned counsel appearing for the petitioner submitted that the bail application has become infructuous, accordingly disposed of. Yes.
Item number 12.
Yes, pass over. Next.
Item 13.
Please, Your Lordship. This is Tadam matter. Earlier, this honorable court please to reject the bail application by BLPL number 3584 of 2021. That's the order dated 10/12/2021. Now, in the meantime, my lord, the petitioner since custody 10/2/2021, and in the meantime, the mother of the petitioner suffers cardiac problem. I submit the memo, and he suggested for a open heart surgery for interim for a few months, 1 month at least. TBD and CABG advice.
This bail application itself is for interim bail.
No, this is regular bail. IA has been filed at that time, but now in the meantime, his mother has been seriously ill. The IA has been filed earlier to this bail application, present bail application. The petitioner at least
IA is pending or disposal?
IA is pending.
But it is not mentioned in the cause list. IA ଅଛି?
IA ଅଛି.
Kahin? अरे आज mention in cause list पे kahin? हाँ ठीक है. IA number so and so. So the ground that has been taken for interim bail is
earlier taken, my lord. The petitioner at least released few months to settle the dispute with certain securities thereof. Now, in the meantime, last 1 week before, his mother is seriously ill and suggested for open heart surgery. That is CABG.
No, you take specific government. You file an affidavit to that effect.
Yes.
A memo empty file kal habani.
At least, my lord, that is received yesterday.
That's all right, but somebody has to. If you will want to go on interim bail on the ground of treatment of your mother, who is stated to be suffering from heart problem,
Yes,
so you better you file another IA.
Yes.
With specific government and this document be annexed.
Yes.
So have you given a copy to the State Council?
No, OPID matter.
OPID, where is the Mr. You have to give the copy also to the either Mr. Bhuiya or Mr. Patra.
Yes.
So let this matter be there. It will come the next week. You prepare another interim application for interim bail and take that ground and also annex this particular document.
Yes, ma'am.
And copy has to be served on Mr. Bhuiya or Mr. Patra. Okay. The Learned Council IA number so and so. The Learned Council for the petitioner submit that he wants to file another interim application for interim bail on the ground of the ailment of the mother, annexing the medical document. And the matter may be taken up next week. Since its case arises out of OPID Act proceeding, that a copy of the, in case interim application is filed, the copy shall be served either on Mr. Vivekanand Bhuiya or Mr. Patra, who usually appears as the special counsel in such matter for the state of Orissa in such matter. ऊपर लिख देवे Learned Counsel for the petitioner files medical document with a memo which is taken on record. Obliged.
Item number 14.
এটা কোন মিস্টার এক্সটেনশন অফ
extension of time मिला
কোনটা টাইম
dispose of case.
আচ্ছা he that means he has not surrendered.
Yes, sir.
So he was granted interim bail for a period of 3 months. দেখুন IA number 1194 of 2023. This is an application for extension of time. The petitioner was granted interim bail for a period of 3 months as per order dated 19/5/2023, and the bail application was also disposed of. This interim application has been filed in the disposed of bail application for extension of time of surrender. After non-appears like that, after going through the averments taken, I am not inclined to allow the prayer made according to IA stands dismissed.
Item 15.
May I please, your lordship? Kindly have a glance to order dated 11/8, my lords. On my miscase and on the objection of the learned, my learned senior, my lord, filed by the state, my lords has directed me to take instruction on paragraph 4 and also directed the state council to take instruction on the health condition of the petitioner.
Yes, Mr. Tripathi.
Yes, yes, my lord.
This is that case of that parcel bomb.
Yes, yes, yes.
Yes, yes.
Okay, so why you want interim bail on the ground of your ailment?
No, my lord. He is a PhD student, my lord. He is pursuing
That has been
PhD.
had already.
That was, I think, that was disposed of earlier.
Yes, my lord.
You want to, you said that you want to submit the papers, etc. So that was considered, and
My lord, why my lords has kept this matter? In their objection, my lord, they have stated in paragraph 4 that due to long absence and non-payment of fees and non-submission of thesis, they have cancelled the registration, my lord.
So now, what is the question of
on this issue, my lord has asked me to take instruction whether once a registration is cancelled, can he be applied for the second time?
No, that is not. The last order indicates about that. You said that the health condition is deteriorating day by day, and that is why instruction was sought for. That is the order dated 25/8/2023. ଆଉ ତାପରେ କିଛି order ହେଇଛି 25/8/2023
last order is 25/8.
ହଁ ସେଇଟା ତ ଅଛି 25/8 ପରେ ଆଉ କିଛି
ତାପରେ ହେଇନି, ତାପରେ ଆସିନି।
25/8 ର ଅର୍ଡର ରେ ଆପଣ ସେ PhD କଥା କିଛି କହିଲେନି। ଆପଣ ହଁ ଆପଣ କନଫାଇନ କଲେ ଆପଣଙ୍କର ହେଲ୍ଥ କଣ୍ଡିସନ। So now there is no order can be passed on this. So what
and
about
already all of the witness have been examined, but that's it.
No. Out of 72, only 45 has been examined, as per my instruction.
No, that is, we are not on merit. We are on that particular interim application which has been listed.
My lord.
So if you want to move the bail on merit, then you can produce the deposition copies of the witnesses already examined And
No, I have filed the miscase for this PhD and for health condition. my lord,
that order has already been passed. That PhD chapter is over. And about this health condition, what is your stand, Mr.?
Yes, his jail medical officer stated that
yes,
a hard stool and bleeding is, and he was treated as burla.
केबे का रिपोर्ट है?
এটা রিপোর্টটা হচ্ছে 19/8 and further treatment is going on at Burla.
Suffering from fistula, some
fistula ପାଇଁ treatment ଚାଲିଛି ପରା ଆପଣଙ୍କର ବୁର୍ଲାରେ କହୁଛନ୍ତି ତାକୁ ଏଠି
that not curable, my lords. ସେଟା time and repeatedly ତାକୁ operation କରିବ.
The IA number 168 of 2023. There is an application for interim bail. The Learned Counsel for the state has obtained instruction and submitted that the jail medical officer has given his report in which it is stated that even though blood is coming from the stool of the petitioner, but he has been regularly medical treatment is being provided to the petitioner in
and his health condition is now stable.
से जोटा बुर्लारा कोठी अपन गवर्नमेंट हॉस्पिटल ले
गवर्नमेंट बीएसएस जो
बीएसएस गवर्नमेंट हॉस्पिटल हला and his health condition is now stable. In view of such report furnished by the jail medical officer, I am not inclined to grant interim bail to the petitioner. Accordingly, IA is disposed of. The Learned Counsel for the petitioner submitted that out of 72 charge sheet witnesses, 45 witnesses have been examined so far in the trial court, and to move the bail application on merit, we will file the certified copy of deposition of all the witnesses examined so far in the trial court, giving copies thereof to the Learned Counsel for the state. Put up this matter.
My lords, may call for a report from the trial court also.
Acha, status report we also called for.
My lords.
Trial court. Yes.
Because as per the direction, the time was lapsed since long.
So, what do we chhad dega? Status report. Deposition copy to be filed. Yes.
Item number 16.
Item 16, may I please your lordship? Lordship, petitioner is in judicial custody since 6th
Let the PD come, Miller. 302 is there.
Lordship,
first time it has come. First
no,
time it has come.
Lordship, it's a tied up matter, Lordship.
No, it's coming for the first time. What he says, tied up matter is all right, but he has not obtained the case diary.
Lordship,
the Learned Counsel for the state takes some time to produce the case diary. Put up this matter. Go to week shard.
Lordship, I am submitting the bail order of the co-accused persons.
Okay.
That
give to the state council. Learned Counsel for the. Mr. Tripathi will receive it.
Similarly,
furnished some bail order copies of the co-accused persons to the Learned Counsel for the state regarding claim of parity. After receiving the case diary, the Learned Counsel for the state shall examine this aspect. Yes.
I am also giving the deposition copy of the one eyewitness on which basis the earlier bail was rejected, Lordship.
Deposition copy of the
PW
eyewitness was examined as PW 5 is also furnished to the Learned State Council. Yes.
Date may be fixed.
Put a saptah for next Friday. Yes, next.
Item 17.
Please, your lordships.
for bail, the London Council for the State submitted that he has not received the copy of the case diary. So also he has not received the case diary as well as instruction about the criminal antecedent, if any, against the petitioner. So also the social investigation report.
That order is already there, Your Lordship. Your Lordship may kindly come to order dated 28/7.
Put up this matter on 10/11/2023. Yes, next. जो मैंने मेंशन करथिला एथि तो दीटा मेंशन हेतला निहाला आपन को तब सीरियली जीवा ना विल गो सीरियली सी दी जण मेंशन करथिले बेली टक item 56 just a minute. Item 56, the London Council for the petitioner submitted that the bail application has become infructuous and accordingly the same is disposed of.
Item 62 also same infructuous due to got accused.
62 8443 infructuous disposed of.
31 million खाली आसिव status report.
31
status report.
Land Council for the petitioner submitted that the petitioner is in judicial custody.
Since 2021 Miller, out of 19 witnesses Miller, only 4 witnesses Miller
submitted that the petitioner is in
custody Miller. 19/10/2021.
The petitioner is in judicial custody since 19/10/2021 and he has received instruction that
out of 19
witnesses, 19 witnesses,
6 witnesses examined.
6 witnesses have been examined so far in the trial court. Let a status report be called for. Matter be placed on such and such date. Go to Saptah Register Judicial send the copy of the order to. Yes.
Item 18.
Mr. S.K.SAHOO, not there. Next matter.
Item 19.
Please, Your Lordship. My Lord, in this case, this present petitioners moved bail application before this honorable court and it was, my Lord, rejected. And thereafter, my Lord, again, this present petitioners filed this application on the changing.
7250 of 2020.
My Lord, I have given the number that.
But that relates to Johan Majib.
That other 2 co-accused persons, my Lord, they have already released on bail by this honorable court.
What about your earlier bail application?
My Lord, my 6112 of 2021 disposed of on 9/1/2023.
Upon par bail order copy is she? Your rejection order?
No, my Lord.
Then?
Yes. Yes, my Lord, I have annexed, my Lord.
Which number page? সেটা জোহন মাঝির হচ্ছে দেখলে আনলে so that was passed on 9/1/23.
My Lord. And in the meantime, my Lord, no progress in the trial. Out of 37 charge sheet witnesses, my Lord, till date, no witnesses has been examined.
Oh, but that was disposed of that. If the case is still sub judice, you are liberty to renew the prayer for bail. So then you moved for bail before the trial court.
My Lord.
On 1/2/2023.
My Lord.
Your bail application was rejected.
My Lord.
So it was 346 kg of ganja.
My Lord. And 2 of the co-accused persons, they have already released on bail.
No. What is the stage of the trial?
Stage, my Lord, charge has already been framed. But till date, my Lord, no witnesses has been examined.
And you are a man from?
UP, my Lord.
Okay. So, Mr.
Yes,
Tripathi, you made the address verification. The London Council for the petitioner submitted that the petitioner is in judicial custody since 8 of the area.
My Lord.
List of
my Lord, I am in custody, my Lord, since 24/8/2020.
लिख ले 24/8/2020
and my lord charge sheet filed on 3/3
and he has instruction that no witness has been examined
my
so
lord till
far
now.
in the trial court. Let a status report be called for from such and such date. The learned counsel for the state submits that since the petitioner is a man from such and such in the state of Uttar Pradesh, will make the he'll take the steps for making address verification, whether the address furnished by the petitioner in the cause title is correct or not. Put up this matter on such and such date. Status report be called for. Date de debe e karibe. The free copy of the order be handed over. Asi jota lekha jaye eta abo SP Gajpati Parla Khemudi shall make necessary communication with the superintendent of police once. In that respect. Yeah.
Item 20.
Tied up matter, my lord. Your lordship call for the status report. Your lordship can see the order dated 19/5/2023.
Status report maghaithila.
Your lordship can
Kebegar order ta.
19/5/2023. Thereafter 28/7/2023. Thereafter 4/8/2023.
Status report as jaichi. That is dated
interim bail was granted by lordship and he has surrendered in time. Until date, no trial has been commenced.
No, interim bail kebe diya itla?
Your lordship granted interim bail on 29/11/2021. Sorry, my lord. Your lordship granted on 16/9/2022 and surrender on 22/2023. 16/9/2022.
BLAPL number ta kon
3816.
3816 of
2022.
2022. Order dated
16/9/2022.
And you have complied that order?
Yes.
All right. The learned counsel for the petitioner submitted that initially the petitioner was taken into judicial custody on, have you got that date?
19/7/2020.
19/7/2020. Since there was delay in commencement of trial, he was granted interim bail for a period of
3 months.
3 months in BLAPL number 3816 of 2022 as per order dated 16/9/2022. And after availing the bail period, the petitioner surrendered at right time. Learned counsel further submits that till date there is no progress in the trial. Status report was called for, from which it appears that on an account of non-availability of C report, the charge has not been framed. In view of the submission made by the learned counsel for the petitioner and hearing the learned counsel for the state, and taking into account the period of detention and non-commencement of the trial and the conduct of the petitioner in complying with the earlier order of interim bail, I am inclined to release him on interim bail for a period of 3 months. He shall appear before the learned trial court on each date when the case would be posted for trial and shall not indulge in any criminal activities, violation of any terms and conditions shall entail cancellation of bail. Bail application is disposed of. Rest of the matter next week.